That petitioner are the BSc pass nursing male candidates. Nursing male candidates. But initially in 2016, the government passed a notification where the ratio
New motion or hearing?
new motion.
When you have filed it?
It is number is 21691. It is not appearing in the list.
Whether it was appearing previously in the list?
Not your lordship.
No. Before the coordinate bench, it was appearing. It was appearing.
Actually, we have filed initially a appeal application in the nature of appeal, but the division bench of this honorable court has told that appeal will not be applicable in this matter since it's a service-related matters. So thereafter, we have filed a new, my lord, writ petition. So our my lord issue only.
So why matter has gone out of list?
This was appearing before the early erstwhile.
Yes, bench. Then
thereafter, my lord, we did not mention there. That is why it is not appearing.
Yes. Now, what is the urgency?
Urgency is, my lord, the notification of 2016 was for 33% reservation both for male and female BSc pass candidates. Subsequently, in 2018, a notification has been passed by an amendment
for admission in nursing.
Admission in nursing.
So, admission in nursing, how is a service matter under Group 6? It will be higher education matter. Because the university is West Bengal University of Health Sciences. How it will be classified as
recruitment?
No, for admission in nursing course.
No, madam. For the recruitment process, madam.
In government hospitals?
In government hospitals.
In which hospitals?
Well, across the state, madam. Across the state, because the amendment has been effected entirely.
Then the question comes whether the writ petition is maintainable at this stage, or you have to move the administrative tribunal.
By the nature of the writ petition, we are challenging the virus of such amendment, madam. The amendment of 2018, madam. Otherwise, the amendment.
So, what is the urgency?
Urgency is, my lord, presently a recruitment process has been initiated, my lord. We have mentioned that before the division bench, my lord. Division bench has considered, but since the matter is relating to the service in nature, that is why the division bench has hold that appeal will not be applicable, and that recruitment process is going on. My lord.
This is when it has started.
My lord, it is started in the month of September 2025.
Then it is already over.
Your lordships kindly take up as per your lordships convenient on any date, my lord, next week or any date, my lord, any date. Your lordships.
So on 24th November.
May I have your lordship to mention? This is an original side matter, my lord.
The notice, my lord.
This is a matter in the original side, my lord. This is against
not the original side mentioning date. Mention on Wednesday 2 p.m.
But I have given notice so that one officer can.
Yes, original side 2 p.m. is the date for mentioning, and it is original side date. Today my officers are not there.
But I have given a notice, my lord. Officer is there, my lord, in court. If your lordship can please.
Where is my officer? Original side.
But I have given a notice, my lord, before.
But today is not the original side date. We have not allowed others. Why you are mentioning today? So appellate side matters will be taken up. Original side Wednesday 2 p.m. Come back. Unless and until it is extremely urgent. If it is very urgent, then you can mention.
Item number 1. Item number 1, I beg to appear for the full authority, my lord.
Your lordship, my senior Mr. Vimal Kumar Shahi will be appearing for the state through virtual mode.
Who is for the petitioner?
I am for the petitioner.
Yes.
But this matter relates to revocation of illegal suspension order.
Revocation of suspension order.
Yes, my lord. Thereafter, my lord, during pendency of this case, my lord, the board issued a final order for compulsory retirement. That I have already challenged on the basis of CAN 4.
Now, in the writ petition, what you have prayed for?
Revocation of, in writ petition, my lord.
Revocation of suspension.
Yes, suspension goes on the basis of that, my lord, final order. And final order I have challenged before CAN 4, my lord. In CAN 4, I have challenged that So this is a continuation of
Petitioner was working as
the headmaster, my lord, at Bolarampur Monmotonath Vidya Mandir, and he has 20 years of experience as a headmaster. Not
now this during pendency of this writ petition.
yes, my lord.
There is an order of compulsory retirement.
Yes, my lord.
Where is that order?
That is, my lord, can 4, file can 4 application, my lord.
Can 4.
Yes, my lord. Can 4.
Can 3, can 2. What are other can applications?
Can 1 and can 2 is the early disposal. Can 3 is the amendment petition, because I've challenged that order of Justice Shen before the division bench. Division bench asked me to file amendment petition before this. That is the can 3 application. And can 4 is the application for revocation of final order with regard to the compulsory.
Yes, where is the order of final order passed by the board?
Yes, that is at page can 4.
Page 20, 19.
18. It starts from 18. Final order 19, my lord. It starts from 18. And operative portion is
Just a minute. All parties are present. School authority.
এগুলো তো দেয়নি।
But this is a fresh cause of action. How in the writ petition which was filed for revocation of suspension an application can be filed challenging this order of compulsory retirement?
Because, my lord,
Because the charges, nature of charges, then how the inquiry was conducted, those are to be dealt with by this court in a separate writ petition proceeding.
my lord, that I have initially I have understood.
Because
but
you have filed the writ petition questioning suspension order
Yes.
and praying for revocation of suspension order.
And during
Now,
pendency,
during pendency, this order of compulsory final order in connection with disciplinary proceeding was passed.
but this is the
Now, how in this writ petition it can be gone into?
but this is the continuation of earlier
No,
proceedings. So for your
suspension is completely different thing. Suspension is a stopgap arrangement. So therefore, if suspension is challenged in a writ petition, that cannot be enlarged into a writ petition for questioning the disciplinary proceeding initiated against the petitioner. How this is permissible?
but my lord,
Entire dimension gets changed.
but my
So
lord,
far this matter is concerned.
but I thought this is my realization. I may be wrong, maybe right, my lord, but probably wrong. But thing is this, my lord, if I file another fresh writ petition, then same cause of action will come.
Maybe
That-
it's a completely different
that-
cause of action.
Yes, well, but
How in the writ petition we're praying for revocation of suspension and the final order of punishment can be subsequently challenged because your prayer is completely different.
no, my lord,
In order to attack final order of punishment,
yes,
you need to substantiate that the proceeding or inquiry which was conducted against you and the disciplinary proceedings not proceeded appropriately. So you will be handicapped in questioning this compulsory retirement order. Because the basis of your writ petition is for challenging the suspension order and praying for revocation of suspension.
But-
in the midst, final order of punishment in the form of compulsory retirement was passed. So therefore, in order to get relief, you need to challenge the final order of suspension based on the loopholes of inquiry proceedings. If those are not agitated or if those are not highlighted in your writ petition, how court will enter into this?
yes, sir. Ma'am, I am confused. Only one thing is this, my lord.
Moreover,
I-
it's an appellable order, Your Lordship.
Let me say,
Final order is an appellable before the
I-
Commissioner of School
Yes,
Education.
it is also an applicable order under 2018 rules.
I am confused on one ground, my lord.
Which rule? Rule 17, 2018 rules. Which?
18 rules.
Yes, this is rule 17 appellable order because I passed several orders directing the appellate
yes,
authority. Probably this is rule 17.
No,
Show
my,
me the rule.
my submission is this, my lord. If I file another fresh writ-
No, now first you have to approach the appellate authority.
same,
It is an appellable order. You have to prefer an appeal before the Commissioner of School Education. So don't waste your time. Don't waste your time here.
So after appellate authority, then I have to file another fresh writ petition.
Because I am telling Ms. Bhattacharya, so far inquiry is concerned and the report of the DI that all charges are proved proximately.
Difficulty, my Lordship. Show cause he never replied.
I have reservation.
No, show cause he never replied. Charge sheet he never
Maybe,
replied.
meaning thereby all charges are proved proximately.
That is, my Lord, can be decided.
DI is saying.
My Lord, difficulty, he never appeared. Never replied in show cause, never replied charge sheet, never
Very
appeared.
well. Show me the provision relating to
Even,
appeal.
my Lord, before
10, my
passing
lord. 10.
the
10.
My Lord, even my Lord, before passing the final order, Your Lordship, a show cause was given to him.
No, matter is pending before the High Court. That is why I did not.
No, but there was no order of, there was no restraint order. So far disciplinary authority is
Because
concerned.
they have taken a step in their own way against me. But I
Yes, but there was no restraint.
respect the honorable court.
Appreciate the
I-
court. There was no restraint order in your writ petition that not to proceed further in the disciplinary proceeding issue or not to pass final order.
Then
So there was no restraint. Board has passed a final order and that is also an appealable order.
Honorable Lordship, in August
one thing.
2024, before passing
No,
the
no,
final
allow
order,
allow
she
him.
was
Allow him. It is his writ petition.
One thing is that
Yes.
when the matter is pending, may not be restrain order. The nicety of justice that this is a high court. Matter is pending
No,
with
no,
high
no,
court.
no,
The
no.
board is
You are completely under the wrong premise. Even if your suspension issue is pending, where is the bar in passing final order in connection with disciplinary proceedings? Then all the disciplinary proceedings will be frustrated.
I did not participate.
In other cases, suppose there is a serious charge and a disciplinary proceeding is initiated, and in anticipation of or in contemplation of disciplinary proceedings, a person has been suspended. Forget about the present writ petitioner. Now, if suspension order is challenged and praying for revocation of suspension order, does it operate as bar so far disciplinary authority is concerned to proceed with the proceedings? Answer is no.
Moreover, Lordship,
Fate of the
provided
suspension, but
a person is under suspension, proceeding is to be concluded within 90 days. Well, that is also a rule.
Find it.
বেরিয়ে গেছে, একটু দেখবে।
বার করাতে বলো।
Well, rule provides if a person is under
So
suspension.
therefore, let me dispose of the writ petition, granting you leave to prefer an appeal under Rule 10 of 2018 rules before the Commissioner of School Education. And if there is delay, is there any provision to prefer appeal within certain time?
Within কত?
my lord, yes.
3 months. Person. Subject to correction.
That 30 days.
And my lord, Commissioner of School Education.
Just a minute.
Period shall be provided for 3 months.
3 months, Your Lordship.
And there is a provision for condonation of delay. Proviso to Rule 2, Sub Rule 2, Rule 10.
And my lord, may I
And
submit
even
one
Lordship may also
My lord.
grant
Issue.
My lord, one thing, my lord, and against the order of TI, my lord, Commissioner of School Education has given me clean sheet.
No. That is a misleading statement, one.
My lord, an audit report.
In the
Commissioner of
the writ petition along with connected applications. No, connected applications. Writ petition was assigned to this court by the order of the then acting Chief Justice on 17 September. The writ petition was assigned by the Honorable Justice Shoumen Sen, the then acting Chief Justice, VD order dated 17 September 2025 to this court, and is accordingly placed in today's supplementary list for consideration. Next paragraph. Writ petition and the connected applications are heard in presence of the learned advocates representing the parties. Stop. Next paragraph. In the writ petition, petitioner being headmaster of Bolorampur MN Vidya Mandir within bracket HS close bracket. South 24 Parganas. Herein after referred to as said school. Within bracket said school quote unquote. Prayed for revocation of
May I take your lordship's leave? May I take your lordship's leave?
yes revocation of suspension order dated 30 January 2024. So, during pendency of this writ petition, final order in connection with disciplinary proceeding initiated against the petitioner was passed. On 25th July 2025 by the President, West Bengal Board of Secondary Education within bracket for short board quote unquote close bracket. Thereby imposing punishment of compulsory retirement with appropriate rate of pensionary benefit upon the petitioner with effect from date of receipt upon the petitioner with effect from the document. State order of state order final order of punishment dated 25th July 2025 is brought on record by preferring an application being Can 4 of 2025. Stop. Petitioner prays for issuance of mandamus and to set aside of final order of punishment dated 25th July 2025 as well as revocation of suspension order dated 30 January 2024. Next paragraph. In the writ petition, issue is confined to suspension order dated 30 January 2024 and prayer was made for revocation of the same. Revocation of the same. When take it before disposal of the writ petition, when final order of punishment before disposal of the writ petition, when final order in connection with the disciplinary proceeding is passed by the President of the Board on 25th July 2025, that gives that leads to a fresh cause of action requiring a separate writ petition, requiring filing of separate writ petition to question order dated 25th July 2025. Stop. The writ petition which was confined to order of punishment which was confined, or the writ petition which is confined to suspension order and revocation of same, comma, scope of such writ petition cannot be enlarged to examine the validity of the final order of punishment dated 25th July 2020. Stop. Moreover, next paragraph. Order dated 25th July 2025 of the President of the Board is passed in terms of the in terms of Rule 9 within bracket 2 of the West Bengal Board of Secondary Education within bracket appointment, confirmation, conduct and discipline of teacher and non-teaching staff, Rules 2018. Non-teaching staff, Rules 2018. Within bracket hereinafter referred to as said rules of 2018 close bracket, said rules of 2018 quote unquote, which is an appealable order under Rule 10 of the said rules of 2018. Appeal shall be presented to the authority to whom appeal lies.
Yes.
Now, where it is subsequently clarified that commissioner is the appellate authority.
Yes, my lord, definition clause.
Show me the definition.
Yes, definition, my lord. 2C, 21C. Appellate authority means the commissioner.
Yes.
And if commissioner means commissioner of school education.
Yes, that is.
Yes.
হ্যাঁ কি বলছিলেন? Rules of 2018. Stop. Appellate authority is defined under section 2 or under rule 2. Now, এই সেন্টেন্সটা কেটে দাও। Commissioner of School Education West Bengal is the appellate authority under rule 2 of the said rules of 2018. Therefore, petitioner is required to prefer appeal in terms of Rule 10 of the said rules of 2018 before the Commissioner of School Education. Stop. Next paragraph. However, on perusal of Rule 10 within bracket 2, it appears that appellant is required to prefer appeal within 3 months from the date of within 3 months from the date of receipt of final order. But here in the instant case, হেয়ারটা কেটে দাও। But in the instant case, President of Board passed final order on 25th July 2025 and 3 months and 3 months টা কেটে দাও, and time stipulated to prefer appeal has expired. It needs to be taken into consideration that after that the petitioner, in connection with pending writ petition, filed an application being can 4 of 2025 on 9 September 2025 in order to question said order dated 25th July 2025, comma, which is within 3 months from the date of receipt of final order, or which is within 3 months from the date of receipt of order dated 25th July 2025. Stop. Therefore, provision to Rule 10 within bracket 2 is attracted, and delay in preferring appeal in terms of Rule 10 needs to be condoned by the appellate authority. In the event petitioner prefers appeal against order dated 25th July 2025 within a period of fortnight from date. Stop. If appeal is preferred within the aforesaid date, appellate authority shall dispose of the same by 90 days from the date of presentation of the appeal, and decision to be communicated to the petitioner by fortnight thereafter. Next paragraph. Writ petition and the connected applications are disposed of. However, there shall be no orders to cost urgency.
At last, I got my lord. Get
Take it back, take it back. Your mobile, Mr. Dey, your mobile. দিয়ে দাও, জাজমেন্ট ফর্মে করে দাও, ঠিক বলেছো।
Mr. Ahmed. Raisi Ahmed.
First day to be mentioned, disposed of.
Usually to be mentioned, date has been fixed or
All parties are present.
Yes, that's right. Yes.
Item number 2, my lord, Mr. Indrajit Dasgupta appearing for Union of India. My lord, he is not well, my lord. I'm seeking for
Who? Indrajit Das.
Mr. Indrajit Dasgupta for Union of India.
Who is for the petitioner?
I am appearing on behalf of the petitioner.
What has happened to him?
My lord, he is not well.
Mr. Topun
Not well, my
Bhanjo is, my lord,
So when he will be able to come?
My lord, tomorrow, day after tomorrow.
Tomorrow.
Day after-
Today is not
day-
well
day-
and
day
tomorrow
after-
he
day
will
after
come.
tomorrow, day after
my lord, we were told that Mr. Topun Bhanjo learned that
Yes, where is Mr. Topon Bhanjo?
My
we
lord,
served him, and
I-
last time accommodation was sought for on his behalf. Okay,
My lord, he is before another bench, my lord. The junior counsel is before another bench.
But last occasion, same prayer was made.
Lord,
If somebody is not well, I cannot, my lord, say
It
anything.
will be placed before the regular bench.
my lord, not today, my lord. My lord, he is.
What is the urgency?
My lord, urgency is that this medical examination is going on subsequent to, my lord, the physical standard test. That is the urgency.
Constable GD.
My lord.
Constable GD.
Yes, my lord. Yesterday I had the, my lord, pleasure of assisting your lordship in
So
some matters.
is there any adverse report medical report.
Yes, absolutely. My lord, the appellate board, my lord, my case is very small. The appellate board has also rejected my contention because there is, my lord, there is twofold. First examination is held, and on the same date, my lord, I will show you to your lordship the rules. In the same day, I can prefer an appeal if my height is not satisfactory. That appellate board also, my lord, has said that I'm disqualified. I'm on the other side of 170. That is 170 centimeters.
170.
Yes.
If it is 170, then you are not coming within the
No,
zone.
I'm not coming into the zone.
If it is fraction of
169,
1 centimeter, then yes.
Then the rounding off is applicable. From 169, I will be considered. That is not my case. Now, my lord, so far as the rules are concerned, my lord, there is no provision of any departmental appeal from the second, my lord, second measurement.
That is review.
Yes.
But yesterday he passed an order.
Yes, my lord has passed an order. In that case, my lord, lordship held that that rounding off will be applicable only after I prefer an appeal.
Is.
Your lordship held.
And the appellate authority was directed to decide
this matter in a time period. Now, my lord, that is altogether different. My lord, this matter is, my contention is that there is no provisions for any further measurement by the department. Now, my lord, in a subsequent, my lord, not on subsequent, my lord, in an earlier similar.
So you are submitting that the provision to prefer appeal is not applicable in this case?
Yes. No, applicable. Appeal has been preferred.
Oh.
They have denied. So
denied means they affirmed the measurement which was made by the first authority.
So they made this other measurements which is on the other side of 169. So I'm not qualified in terms of the rules. That is the fact. Now, my lord, my case before your lordship is, on an earlier round, when I participated, my height was held by the same authorities as 170 in both the cases, both the petitioners' cases. Now, my lord, whether I am, my lord, entitled before an read court, my lord, when the departmental remedy is over in one round, in the other round, my lord, I was held to be qualified so far as the height is concerned, that if there is this discrepancy, then whether your lordship may direct some other, my lord,
There is no use of hearing you today. He is praying for time. Not today. Not today. Come back.
Only, my lord, one indulgence I will pray for, my lord. Your lordship will allow me to assist your lordship virtually tomorrow.
Yes.
Grateful.
Place your case. Not today.
Item number 3.
Your lordship, Mr. Desai is appearing on behalf of the respondent. She has attended the due to some medical emergencies. Kindly.
Who is appearing?
Mr.
Yesterday also time was taken.
Yes, your lordship.
Every day that cannot. Sorry. Just a minute. Affidavit service filed. Where is he?
He couldn't come to court. He couldn't come to court due to some medical emergency. He isn't feeling well since.
And where is Miss Bonani Bhattacharya? Ask her to come. Ask her to come.
Lordship, kindly give a short pass over. Let me call.
Just a minute. So you are relying upon this medical report of 8 October 2024.
In fact, it's their medical.
We will wait for a date. Let them come up with an instruction. Yes. Not today. Tell Mr. Jha to come with instruction.
Item number 4. My lord, item number 4 and 5, my lord. Limited here, my lord. Only today morning, my lord, I have been informed, my lord. I don't even have the brief.
4th November.
So, my lord,
What
I
happening for Union of India?
no, he's the for petitioner.
Petitioner, my lord.
Petitioner.
My lord.
I will take a copy from
What
Mr.
Union of
Ghosh.
India?
No, my lord.
Here, my lord, in the coal sector,
What is the
he is
matter
also
of-
the petitioner.
Matter, my lord, I am praying for the stay of the disciplinary proceedings during pendency of the criminal proceedings, my lord, as followed by the Honorable Supreme Court, my lord. And already
In Paul Anthony's case, will
Paul Anthony and recent 2 judgments of the Honorable Supreme
I
Court
will also
on the
show, my lord, the judgments.
same line.
to that.
department you are working.
My lord, in Eastern Coalfield, my lord. And already, my lord, 3 stay order has been granted by this honorable court, my lord, followed by that.
Those matters.
I will go to your lordship, my lord.
My lord, I don't take
My lord,
your
Justice
much
Honor-
time today, my lord, when I'm
My lord,
paying.
Justice Aniruddha Rai already passed, my lord, 3 orders. My learned friend has appeared.
But they
Followed-
are, my lord,
followed-
my submission without.
My lord,
Because, my
followed
lord,
that order, my
no,
lord.
no order for affidavit, my lord, but the matter was to be heard, my lord. So it is fixed. I will mention it before your lordship also. The matter is returnable, my lord. Those matters. So my submissions are to be made in those matters. It's a temporary and injunction order was given, my lord, interim order. So those matters are. So here also, my lord, I will take those points, but I do not know what is the subject.
Don't
what
have
is
the
the-
brief.
No, I don't even have the brief. Today morning I have been said, my lord, I will take it. I have talked to Mr.
Yes,
Ghosh. I will take a brief
Yes,
from
that
him, my
can
lord.
pay for ECL.
ECL, my lord. So, my lord, any day after 19, my lord, in the meantime, my lord, I assure, my lord, nothing will happen, my lord. I will inform them not to take any steps in this matter. Even if there is a date, there will be an adjournment.
Any day, my lord, as your lordship.
What is the present stage of the proceeding?
Well, just they have, my lord, issued notice for, my lord, appearance, my lord.
Charge sheet was issued.
Charge sheet issued,
So
replied.
inquiry notice has been issued.
Yes. I'm praying for stay of that, my lord, inquiry, my lord.
It will come on 20th November.
21st, my lord.
21st Friday, there is a difficulty application date.
Then after that, my lord, 20s, I have, my lord, another matter.
24th November.
24th
24th.
November. My lord. In the meantime, my land, because day after tomorrow is the date.
Issue.
Very good.
Matter is file your affidavit of service.
Yes, my lord.
Where is your affidavit of service?
My lord, I have copies, but my lord, due to the server issues, my lord.
I think, my lord,
They have-
because
my
they
lord,
have
I have
intimated me,
prepared.
they have not yet received.
But I have
So,
prepared
but-
the affidavit of service.
Matter is heard in presence of the learned advocates representing the petitioner and Eastern Coalfields Limited being the answering respondent. Stop. Learned advocate representing the petitioner submits. Inquiry notice has been issued to the petitioner asking him to appear before the inquiry officer, which is under challenge. Stop. Learned advocate, next paragraph. Learned advocate representing ECL has prayed for accommodation to obtain instructions. Stop. It is submitted on behalf of ECL that till next date of hearing, no steps to be taken relating to inquiry proceeding which is contemplated against the petitioner. Stop. List the matter for further consideration on 24th November 2025.
Get
That's the same heading.
My lord.
Get
My lord, next matter is same.
4-5.
File your affidavit of service in course of this day.
Well, because server is not working. I have prepared my lord affidavit of service, but problem is my lord the delivery report due to
আচ্ছা
the,
একটা লাইন নিচে অ্যাড করে দাও learned
On the
advocate for
next
the
day, my lord,
petitioner,
on the next day, my lord, I
learned advocate for the petitioner undertakes to file affidavit of service on the next date.
my lord.
Grateful.
Next.
Item number 5. 4-5, my lord.
4 and 5, my lord, same.
Yes, let the file be please. Same issue.
Same.
Inquiry procedure
Same.
notice has been issued.
Yes, same.
Same order.
Grateful. Item number 6.
I appear for the petition.
Yeah, I am led by Mr. Devasis Banerjee. We have the respondent number
There
5
are-
and 6.
Led by
Mr. Devasis Banerjee.
I am for the
I-
state, my lord. I am led by Mr. Honor Lalit GP, my lord.
where is he?
Well, there are 14 petitioners. Court fee have been paid. Now, well, may I just, Lordships, may not be required to see. Well, the Supreme Court, after meeting with all the ministers and also the Honorable Chief Justices, they took a decision that in India there has to be an e-court system. So computerization is necessary. So a national policy was framed. After that, initially it was entrusted upon the NIC. So all of us, our initial appointment was through NIC. And the policy required that exactly like X, Y, Z.
Who is appearing for High Court, Calcutta?
Mr. Devasis Banerjee. Mr. Devasis Banerjee, Lordship.
Well, High Court, may I just first say, if I do the reverse, what today I'm asking, because High Court is with me. The Honorable High Court took a decision so that we get that the equal pay. In fact, this is not a case.
Where is he?
Lordship, he is courtroom number 18, Lordship.
It doesn't have any scope for interim order, but if I can give just the bird's eye view. The 14 system officers are the only persons in High Court and all districts who are managing the entire computer systems. Whenever they are the highest persons, they have all the qualifications like BTech and B, whatever is the requirement. The High Court made a rule in 2014, and the rule required our pay has to be the equivalent post of the state. We have found that the similar persons, like what we are working as a system officer here, state, they are getting more. So first, our representation was made before the Honorable High Court. A committee was formed.
All are working in High Court?
Yes, not all all in they are the highest persons dealing with the technical aspects of it. So these 14 are in control of all technological things of the Honorable High Court as well as all the districts.
Where they are posted?
They are posted all in several districts.
Not in High Court?
Excepting one. One person, he is in High Court.
Yes.
The number one, he is in High Court. Now thereafter, my lord, if Lordship straightway see, 193, when it was placed before the Honorable High Court, that's the decision of the Honorable High Court. 193.
Yes.
Now this 193 has been considered and rejected by the state, which is
Subject matter of challenge.
So I'm not seeking any interim order because this is.
Where is that order?
Yes, that is an 194. But why 193 was because the committee of the Honorable High Court could have also put a full stop there. Why they also wanted to forward to the state? Reason was the rule framed by the High Court itself, page 129.
No, but the order, Principal Secretary
yes, Uncle, that is
refused to
194.
really.
That is, yes.
Just
It doesn't contain much reason, but in any case, there is a rejection.
That is the P15.
Yes, just correct.
they regret. Long draw.
ঠিক আছে এগুলো তো বলতে হবে মুখে বলে তো হবে না মুখে বলে আছে 16 চাইছে জানিস তো পড়েছিস তো
Why?
15th October 2023
Because
order.
it was not made known to us. We got it in 25 to RTI. That we have stated also. Now, why my
They have stated
that we came to know only we got this only in 25 May.
entry level pay scale so far system officer is concerned is 16.
Yes. Now, Lordship, kindly have a look at
well,
Scale number 16.
they are getting 14
30.
they want 16
They are getting 13.
I'm sorry 13 they want 16 this is the dispute but malad this has to be malad on affidavits malad there are many
no,
things
not about it.
no question of anything about
Correct,
it.
correct. I'm not.
No, Mr. Dhawad has also
I have.
submitted.
I can't say
There
something.
is no
that-
scope for passing any.
Correct. Only one thing.
I am also not very I'm not that way instructed
No, no, it has a.
to address your lordship. It has many
15, 30
ramifications malad
But only one page I want to show that when this was formulated itself in the rule, in the statute, page 129, can you ever come to 129? Based on the national policy on that for every high courts, the rule was framed under
29.
rule 8.1.
129.
Yes.
Yes.
129
Kindly see 8.1. That's the
13 এটাও 13 এটাও 13
Equivalent post.
I'm not seeking any.
Holding equivalent post.
Yes, exactly.
but
And all of them are the BTech. All of them. So in case of, but this is not a shortcut kind of matter because
well, as has been observed by your lordship malad this is I pardon lordship
Yes.
this is 5th of October 2023 and just it is 2 years almost more than 2 years
A case is made out that it was obtained. Copy of this order was obtained by the petitioners
26th of May.
pursuant to an RTA application.
yes if that is the explanation malad the delay but malad there is apparently there is delay anyway malad if they have
And not only this is a continuing cause of action. If I'm entitled to a particular scale
I agree
and which is being denied
I
to me,
agree Well, I
even
think
court proceeds on the
I
premise
said I
that
have got
order
some
dated
experience
5th October 2023. Still, we have got a petitioners
lordship
are
lordship
entitled.
I'm not disputing at all I agree
There was a filter.
because I have told you lordship that said I have some experience of that side so I know.
If we were all unreasonable, the honorable court would not have.
Affidavit of service filed on behalf of the petitioners
Longer time, little longer time be given because
taken on record. Is taken on
Small
record. Court will prefer to hear you on this point.
Well, it will be
Being
my
government-
privilege. It will be my privilege.
Yes. Affidavit of service filed on behalf of the petitioners is taken on record. Next paragraph. Petitioners are system officers working in High Court and district courts throughout the state of West Bengal and have common grievance of not upgrading their scale of pay. To the scale of pay extended to their counterparts working under state government. Stop. Based on one representation dated 18th February 2023 of the petitioners, Registrar General High Court Calcutta forwarded the issue to the Principal Secretary to the Government of West Bengal Judicial Department for taking decision on the claim of petitioner for upgrading their scale of pay. Stop. Next paragraph. Principal Secretary with a memo dated 5th October 2023 refused to upgrade scale of pay of the petitioner based on observations made by the Finance Department. Stop. Such memo dated 5th October 2023 is questioned in this petition. Stop. State respondents are represented by Mr. Shopon Dotto, learned government pleader, and High Court is represented by Devashish Banerjee, by Mr. Devashish Banerjee, learned advocate. Next paragraph. Having considered the issue involved in this petition, court finds there is no scope for passing an interim order. Stop. Issue needs to be delved into on filing of affidavits. No. Next paragraph. Let affidavit in opposition to this writ petition be filed by by 4 weeks. By 4 weeks from the date of by 4 weeks, and affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging evidence.
Only, my lord, there are 14 petitioners, my lord. I don't know. Court fees.
Yes, yes. That was my first sentence.
That he knows.
No,
I am aware.
I know, but then
Court will ask.
I'll be failing in my defense if I don't point out. I was not here.
Because I know that.
No,
I began. Only can one sentence be replaced? Like, I am not seeking interim order. Lordship has recorded one sentence on refusal.
There is no scope for passing an interim order. Yes.
Instead of, because that's a Lordship decisions, can you Lordships kindly say that recording my submission, I am not seeking an interim order.
There is no scope for passing an interim order to Kerala.
Record
Learned advocates representing the petitioners and state respondents have jointly submitted. Learned advocate representing the petitioners has submitted has not prayed for learned advocate representing the petitioners is not seeking for any interim order.
Yes. Very well.
Is not seeking for any interim order.
That's a grateful.
Administration will also file affidavit because we don't have any as such role to.
You don't have either the High Court.
Yes, yes.
Well, we have only forwarded the representation before the state government, and the state government.
That I've seen.
Well, so we also need to file a separate affidavit, my lord.
Yes, if you want.
You have framed a rule which is in my favor, but it's about money and no money thing. That's it. If you have
Item number 7.
This matter, my lord, I am a
Identical matter. Item number 8.
it called as a kinam.
But
Important.
who is appearing in item number 8?
I am appearing for the railways, my lord.
In item number 8?
Railway authority, my lord.
In 8 also?
It is Dilip Kumar Singh.
Yes.
This, let me say, just I have soft copy I have received, my lord. Both are same.
Identical. Are you appearing for the railways in
Yes,
item
sir.
number 8?
By the Ministry of Law.
Call item number 8.
Item number 8.
This is the case for pending proceeding, departmental proceeding was started. One of the substantial question of law involved in this case. That petitioner before a lawsuit is an instrument of railway question. On the basis of public complaint, a criminal case was initiated against him, as well as the defamation. Hello? The rule provides.
My lord, can it be taken at 2 p.m., my lord?
Why?
Soft copy I have received. I get it hard copy only. 2 p.m. my lord. Nothing would work.
Come back tomorrow.
Yes, sir. That would be better.
2 p.m. No, tomorrow. Not 2 p.m. tomorrow. He is not having the copy. No.
Soft copy I
So
have.
7 and 8 tomorrow, not today. 8 will be passed. Very well. Let it retain its position 7 and 8 tomorrow, not today. In both matters, Mr. Gupta, you are appearing.
Hard copy. Like,
Item number 48 for monthly list.
For the petitioner. Yes, not me. Who is for the respondent? Mr. Dhiraj Trivedi is appearing in this matter. And Joyita Dhar, where are they? Yesterday they did not appear. The time was granted. Today also, I think Mr. Trivedi is there. Yes, come to. Yes, come to. Very well, but they are not there. What can be done? Serve a notice and come back. Kindly, why not do that? Serve a notice and come back. Yes. Kindly pass the necessary order. I will communicate it. Yes. Yes, last occasion, Mr. Trivedi and Dhar appeared. Yes. At the time of call, no one appears for the no one appears for Union of India and no accommodation is paid for. Next paragraph, learned advocate representing the petitioner is directed to serve notice upon the learned advocate representing Union of India by 14th November 2025. Good. Hearing of this matter stands adjourned till 17th November 2025. I will serve in the meantime and before get first.
Item number 68.
Yes.
But as per your lordship direction, my lord, I sub notice to Gaurav Das, learned advocate appearing for the
Yeah, for
But I am for the district judge Paschim Bardhaman. But here, my lord, the state government presence is required because my lord, my lord, the judicial secretary, because my lord, he is the authority. We have forwarded the papers to him.
issue. At the time of call, no one appears for the state respondents. You are for respondent number 5.
I am for the respondent 5.
Who is for the High Court Calcutta?
My lord, Gaurav Das, Mr. Gaurav Das.
High Court Calcutta?
No, board of the state is
No, no, no. High Court Administration. High Court Administration.
Right. Registered General Appellate State High Court.
No,
Board of petition.
But yesterday I served notice to him.
But who is appearing for the state?
My lord, state. Their state was not appear. My lord, I served everyone.
State's presence is what is your prayer?
My lord, my prayer, my pay scale, my lord, from grade 9 to grade 7.
To pay
My lord,
state's presence
as
is,
per order, district judge.
state's presence is required.
because my lord,
Last occasion also.
Last occasion, respondent number 4 এর হয়ে state, my lord, in last occasion, state was not appeared.
Kindly keep it next week.
My lord, I incurred and my lord, sub notice.
No sub notice issue.
Yes.
At the time of call, no one appears for High Court administration and state respondents. The court desires to hear High Court administration as well as state respondents, as the petitioner is praying for upgradation of his scale of pay. Stop. Learned advocate representing the petitioner is directed to serve notice upon the learned advocate who represented High Court administration on last occasion, and also on the learned government pleader, enclosing copy of this order by 14th November 2025. Stop. Hearing of this matter stands adjourned till 25th November 2025. Yes, affidavit service filed on behalf of the petitioner is taken on record.
If you actually record one line that the respondent 5 is represented.
Give your appearance. আচ্ছা উপরে একটা জায়গায় করে দাও respondent 5 is represented by Mr. Mukherjee, learned advocate.
My lord, I challenged here, my lord, the order passed by the district judge. By my learned
Because
friend.
I have passed the order.
My lord, he has to take instruction because I challenge the order passed by the district
Well,
judge.
but upgradation of scale up pay, state's presence is required.
আমি যা করেছি জুডিশিয়াল সেক্রেটারি অর্ডার।
Yes, next matter.
Item number 69.
My lord, 69, my lord, I am appearing for the FCI, my lord. Respondent number 6, I want to file a report. My lord, you will also kindly grant me 7 days time. My lord, I had talked with, I have already prepared.
This matter was taken up.
This matter was taken up.
My lord, the central government of India is the man.
Oh, that report.
Yes. In terms of last order, the respondent number 4 and 6 were required to file a report. That has not been filed.
My lord,
Yesterday there was resolution, Lord, central government advocate did not appear, so your lordship did not take up the matter.
my lord, you will also actually, this is the,
6 and 7 is just two.
26 is FCI, my lord.
well, actually, my lord, we have nothing to say. It is a cabinet decision. They have sent on deputation. We had to accept. But every steps.
And is the Lord FCI.
But the respondent, the answering respondent is my lord 1 to 5.
FCI.
Now, but the ministry has filed a report.
No, no, no. My lord, they are the answering respondents.
But both of them were required to file the report in terms of the last order passed by this honorable court.
Last order was passed on 8th May.
Right. That was the first and last order.
Will you serve notice upon learned advocate representing 1 to 5?
1 to 5.
1 to 5 and yes.
Yes.
Matter is taken up for consideration. in presence of the learned advocates representing the petitioners and respondent numbers 6 and 7. Learned advocate appears on virtual mode on behalf of respondent number 6 and 7 and has prayed for 7 days time. You are praying 7 days time.
Your Lordship, 6 is a daily. Your Lordship kindly give us 15 days time.
15 days.
15 days.
Learned advocate representing the and has prayed for 10 days time to file report in terms of the previous order. Stop. On behalf stop. On behalf of Union of India, no one appears today. Stop. Learned advocate for the petitioners is directed to serve notice including copy of this order upon the learned advocate who represent Union of India being respondent number 1 to 5 by 24th by 14th November 2025. Stop. Next paragraph. Hearing of this matter is adjourned till
Can it be on 25th?
till 25th November 2025.
I'm extremely grateful.
Or better, let it appear in the combined monthly list of December. Same position. Because it will be there in the combined, it will be taken up on 25th from combined monthly list. Stop. Hearing of this matter stands adjourned. List the matter under the same heading in the combined monthly list of December 2025.
I'm extremely grateful.
The next.
Item number 73.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Stop. Same situation prevailed on 7th November 2025. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed for default. Parties to act on the server copy. Next.
Item number 74.
My lord, Advocate Kakuli Samajpati is appearing for the LIC, my lord, and she is unable to come to the court in this week, my lord, because of the medical urgency, my lord. Her only son is admitted in the hospital, but not this week, my lord. She will join the court in next week, my lord, because her son is admitted in hospital in critical condition.
As prayed for on behalf of LIC, or as prayed for on behalf of Life Insurance Corporation of India. Hearing of this matter stands adjourned since learned advocate is unwell. Stop. Petitioner is represented by learned advocate. Stop. Hearing of this matter stands adjourned till করে দাও 17 November 2020. Next.
Item number 75.
Item number 75. Petitioner was appointed as the fan operator of Eastern Coalfield.
Yes.
Now, my lord, thereafter, my lord, suffered an illness
Petitioner was working
as fan operator.
fan operator.
Then thereafter, my lord, due to sickness, my lord, he lost eyesight of both the eyes. My lord, then he prayed for some other alternative job in the Eastern Coalfield. That was under consideration, and subsequently the board has decided. Then it was placed before the medical board. Then, my lord, kindly come to page 15 once.
This primary medical examinations.
Then, my lord, kindly come to the next page. Report of medical examination under Rule 29B. Defective vision. My lord has got it.
Yes, after 3 months, second examination with medical test.
Now, my lord, kindly
Report.
turn to the page 19, 5th September 2019.
Page 19.
Page 19, letter dated 5th September 2019. You are hereby advised to
Just Yes. Yes.
Then, my lord, kindly come to straight away to page 21. I was slapped with a charge sheet on 24th May 2021. You were unauthorized absenting from your duty with effect from 21st January 2019 without any intimation given to the colliery management. Your above acts show gross negligence on the part of your duty under certifying standing order applicable to coal industry, which reads below. Then absence from duty beyond 1 month without sanction leave or sufficient cause, or overstaying beyond sanction leave without valid reason. Then, my lord, kindly turn to the next page. What was the reply?
Now, what is the present stage of these proceedings, discipline proceedings?
The inquiry officer, I'll take your lordship to the report of the inquiry officer.
Yes.
Now, my lord, kindly straight away come to page 27.
Not proved.
No.
Yes. Yes.
Then, my lord, several occasions I wrote that kindly refer me to the Apex Medical Board. I was referred, but till date, my lord, nobody has. My lord, kindly.
No report has been furnished by the medical board.
No.
Yes.
Lordship, not only report, we found, this is the inquiry, we found that really he is unable to do. Then, Lordship, even after filing of his matter, we have called him for the suitable thing, because it's a mining area, very limited scope for a blind person. But still, Lordship, On May 2025, we have requested him, May 2025, during the pendency of the writ. Lordship can look into it. We have given him a chance that please come before my board because this inquiry found is something different. So we have called him. Now, Lordship, the only issue here is I have a provision. During your service period, if someone is
Medically incapacitated,
then there will be a substituted service in the family. So what we often find at the very tertiary stage of the service, everyone gets, because it's a colliery area, everyone has got some problem. Everyone becomes so ill that his son has to be accommodated because these services,
it appears
in
to
this
be
case
genuine
also
case.
he said so. In this case,
prima facie, it appears to be a case since petitioner has lost his eyesight.
Lordship,
it appears
now,
from
Lordship, kindly
the
turn to-
report.
Kindly come to page 20.
A report that defective vision. And
Sure.
petitioner is not in a position. You initiated disciplinary proceedings that failed. It also goes to show.
If your Lordship kindly come to page 20. Kindly come to page 21, Lordship.
Your inquiry officer, come to page 27.
No, that's
please come to page 27.
Yes, Lordship.
Charge-sheeted workman had undergone for primary medical examination held on 27 March 2019 at Swansea Hospital, where he was found blind in both of his eyes. Reports of primary medical examination attached, signed by the medical officer of PME Bangkol area. Now, if you are reluctant to furnish the final medical report, then court will direct the ophthalmologist of SSK, head of the ophthalmology department, to furnish a report. Now, choice is yours.
We will.
In the meantime, 4 months have passed. Last, this writ petition was filed in hard on May 2025.
In the month of
May, June, July, August, September, October, November. 6 months is over. So therefore, if you pray for 7 days time to furnish report, I can grant you.
Lordship, we
Otherwise,
have crossed that stage of report. We accepted our report, we have acted on our report, and we have called him for the suitability. Lordship, kindly come to my letter, which I have just handed to your Lordship, and kindly come to page 20.
Copy the.
Where is the report?
Lordship, kindly, report is with us. Based on our report, we have called him in May 2025, which I have just handed out.
26 May.
26.
No report, only the bunch of papers.
If your Lordship needs the report, we will bring. What I am trying to
since you are
say is,
saying it's a report.
I am saying that
I am not aware. My lord, I am not aware. My lord, kindly come to page 34 of the last annexure of my writ petition. There I have given the reminder on 15th May.
Page?
My lord, last page, 34. Page 34. My lord, kindly come to page 34 once. Last time
it is your reminder.
It is my reminder sent on 15th May 2024. Even then, they did not inform me. This is a news to me.
Yes.
What is your prayer on being declared medically incapacitated?
The consequential
appointment on
Yes.
appointment. Yes.
Yeah.
Now, show me that this that you have called the petitioner on which date? How petitioner? has-
Let them show that it has been even at all.
बोले नहीं, हमें একসঙ্গে both cannot say. बोले नहीं, আপনি बोले नहीं.
Which document was sent?
Lordship, I have handed over to your Lordship.
Nothing
one
is
page.
paginated. Nothing is there.
Yes, it is just we have taken because we are not aware that this will come. We thought that we will place it with report or affidavit, whichever Lordship. And
For
then
last 6 months, you are not aware that this matter will be taken.
no, today, Lordship, I thought that by
You didn't, and your department did not find time to file a report.
file a
Prepare
report, I was not.
for last 6 months.
No. Lordship, kindly see the document which I have handed over to your Lordship. First letter is I have called him, and the last letter is he replied to my letter that he will not come because writ is pending. So the question which my learned senior friend said that he is not aware it's a news, it cannot be. I am accommodating. He said that writ is pending.
Yes, there is a
Now, Lordship,
letter
kindly
by
come
the
to-
petitioner.
Now, Lordship, kindly turn to page 20. Now, kindly come to page.
Show him this letter.
Yes, yes, I've handed over a copy.
Just right now, my lord, I have.
Please see, we have just prepared this.
My lord, kindly fix up a date, my lord.
Why? Lordship, I'm coming. Why it is there? Then, Lordship, kindly come to page 20 of the writ petition.
After 15th May, then 26th May, this decision has been taken.
Yes, yes. We have taken decision. We have called him.
মক্কেলটাকে ডেকেছিল, মক্কেল বলেছে রিট পিটিশন পেন্ডিং, তাই যায়নি। মক্কেলটার কাছ থেকে ডিরেক্ট খবর নিতে পারছে? খবর নেই।
He is that Debu Gop is the son of the petitioner.
No. He is the candidate.
He is the
Candidate.
employee.
He said, writ petition is pending, I will not go. And if you see the page 20, we will get his motive. And then the prayer of the writ.
So why it did not appear? Matter could have been.
My lord, kindly fix up a date. Perhaps, my lord, he can't see anything. That's the problem.
He can reply, he can react, he knows.
He can 6th of May. This letter was issued and due to pendency of this writ petition, your petitioner refused to appear.
Perhaps somebody has given a wrong advice to him. That matter has been filed in the court.
Well, let him take instruction. Come.
Instead of instruction, Lordship, then this is a blind man. We want to cover my own employee. Lordship, we will be fixing another date of this interview in pursuant to this letter.
No. Prior to that, let him take an instruction that what has actually happened, and then after if court finds.
End of the day, he has not come. Maybe wrong instruction or this. So, Lordship, we will give another chance of coming him. Kindly
That
fix
will be
it.
considered. Your submission will be considered on the next day.
Good. না যশোর বলতে ওরা ইনস্ট্রাকশন নিয়ে আসুক তারপরে না সব তো নিয়ে আমার কিচ্ছু লাগবে না দাদা আমার তো এখানে স্ক্যান কপি না দিলে
মেডিকেল রিপোর্ট
কাগজ আর হাতে পাতা স্ক্যান
dated
দিয়ে দিলে এর সঙ্গে এটা
27 March 2019, page 16.
Yes.
27 March 2019. Whereby petitioner to be suffering from defective vision. An application was made for declaring that petitioner application was made by the petitioner for declaring him medically incapacitated. Stop. During course, stop. Next paragraph. During course of hearing, learned advocate representing Eastern Coalfields Limited has placed before this court one letter dated 26th May 2025 issued by area medical officer Bankola area, whereby petitioner was asked to appear before the concerned authority on 29th May 2025 at 11 a.m. Stop. In response to such letter dated 26th May 2025, Vide 2025, petitioner submitted a letter. Petitioner sent a letter, thereby refusing to appear before the concerned authority of ECL on the scheduled date and time due to pendency of this writ petition. Stop. Copies of the letter dated 26th May 2025, letters dated 26th May 2025. And what is the date of this letter, Mr.
Lordship, at the bottom after the thumb impression. Below the thumb impression, Lordship.
28th May 2025.
28th May 2025. Copies are placed before this court and taken on record. Next paragraph. Mr. Dhor, learned senior advocate representing representing petitioner has prayed for accommodation to obtain instructions. Stop. Hearing of this matter stands adjourned till
Except 17th and 18th.
have difficulty 17th
17th and 18th.
till 19th November 2025.
Affidavit of service on it.
Yes, affidavit of service filed on behalf of the petitioner is taken on record.
I'm ready.
Yes, call the list.
Item number 81.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. In order to grant one more chance, hearing of this matter stands adjourned. List the matter under the same heading on. November 2025. Next.
Item number 82.
My lord, Mr. Ujjal Rai is appearing on behalf of the petitioner, my lord. He is on leg at courtroom number 1, my lord.
Not today.
Item number 83.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Stop. In order to grant one more chance to the petitioner, hearing of this matter stands adjourned. Stop. List the matter under the same heading for further consideration on 25th November 2025.
Lord, 83, I'm for the state, my lord. 83, I'm for the state, my lord.
Yes, give your appearance. For the respondent?
Yes.
Yes,
state.
next.
Item number 84.
My lord, in item number 84, I'm being led by Mr. Mukherjee. Yesterday, Mr. Mukherjee was giving a very short background. My lord, I'll just start briefly. He's on his legs. He will join.
Sir, let him come. I'll hear the matter. Where is Mr. Basu?
He's just outside the door, my lord. He's
A short passover in that
He's
event?
only barely a minute away.
So, my lord,
Come back. It will retain its position. Matter is taken up for consideration. Stop. Hearing of this matter stands adjourned till Monday next. There is no pressing urgency.
no, my lord, the only pressing urgency is that we had
Next. Mr. Basu, come back. Yesterday you are not there. Mr. Mukherjee was there.
Sorry, sir.
Item number 85.
We are the respondents. Monday.
Well, 85.
It will retain its position on Monday. Come.
85. I'm with the petitioner.
Yes.
Lots of other respondents.
The petitioner father was the employee of the BSF. Well, he died after retirement 1992 and died 2021. His son is handicapped. We made application.
Employee of which department?
BSF.
Employee of
Border Security Force.
BSF.
BSF. Border Security.
But I have annexed my handicap certificate, page 12, page 14, permanent handicap certificate.
Medically incapacitated.
Page 14.
When he was declared medically incapacitated by the competent medical board.
1998.
1998.
1998. Permanent. Page 14, my lord, permanent.
Page 14.
Yes, ma'am. Top, my lord, medical certificate for the physical handicap person, permanent.
यहाँ पैसा क्यों लिखा है?
कब का है?
ये जब उसके पापा सर्विस में थे तब का है।
41?
नहीं, उसके पापा का तो उसको अपनी एक्सपेक्टेशन
No, how he got appointment? How he got
appointment? Family pension, handicap pension.
Son of the deceased
employee.
Deceased employee. Employee was in receipt of pension.
Yes.
Now, is there any provision or circular
Yes.
for extending the benefit of family pension to differently abled son of employee of discipline force, border security force?
No.
Where is the circular?
CPS amendment, page 9 provides.
Page
9 proviso. What I handed it over. Page 9 proviso last.
When father retired?
1992.
Retired on 9. Tell me the date of retirement.
31st 12 1992.
94.
92.
31st 12 92.
Died.
Then when he died, father died.
Annexing the document. Twelfth April 2021.
21. Then have you made a representation?
Yes, ma'am.
Where is that?
The last page 51. Page 31. One words.
Who is to consider it?
Let's pay and account section.
Yes, who is to consider it?
Lordship, first, given table of page number 15 by the writ petitioner.
Who is to consider the representation?
Respondent number 2.
Pay and accounts officer.
Lordship, yes, sir.
So let him consider and pass an order.
No, Lordship, they have not applied in the prescribed form. There is a specific prescribed form for the disabled legal heirs. Number one. Number two, they have just given a simple letter. Let them to go in the department, ask for that prescribed form. In that, they have to submit the medical report. After that, we can consider it is disabled.
Now, still petitioner is staying at the at this address, which is there in the cost title.
Yes, sir.
Well, I will direct the pay and accounts officer to supply a form by 7 days by post. And pursuant thereto, petitioner shall make an application in the prescribed form seeking family pension within 10 days thereafter. And within 8 weeks thereafter, decision to be taken and communicated to the
Lordship. Lordship, one thing more. My learned friend has given page number 15 of the writ petition that that behind the only one legal heir, Harathan Gain Abdul. But his father at a lifetime, he has given that their daughter is also there. There's not there's no reflection regarding his disability.
Whether the daughter if daughter is not disabled daughter, if daughter is not differently abled, then his daughter is not entitled.
Lordship, absolutely correct. But we cannot say that I am the only legal heir. He has especially written that I am the only legal heir. So there is no such record.
File or affidavit of service.
Lordship.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Father of the petitioner was working in border security force, for short BSF within bracket, who retired on superannuation on 31st December 1992. Stop. After superannuation of the father, he was in receipt of pension and who died on 12th April 2021. What about mother?
Mother already died.
Mother, when mother died?
Mother also died.
Whether mother died prior to 24th, prior to the death of father?
After death of father.
Tell me the date of mother.
1/11/2021.
1st November 2021. 21, just after father's death. Now, mother was receiving family pension.
Yes, yes.
Mother was not receiving.
No, not disabled.
Why?
Only 4
No, she was not disabled. She was receiving.
No, but the wife will get family pension.
Lord, she was getting.
Mother was getting family pension.
Yes, Lord.
কি বলছিল?
Mother not receiving.
No, mother is not receiving any pension.
Mother কবে মারা গেছে এটা বলতে জিজ্ঞেস করছি।
Mother not receiving any pension.
Why?
No,
Till he get.
no. As per instruction, mother was receiving the family pension.
Have you stated that mother was not getting family pension in your writ petition? Try to find it out. Where you have stated that mother was not receiving family pension. কি বলছিলাম? Died 12th April 2021. Stop. It is also submitted that that petitioner's mother died on 1st November 2021. Stop. Petitioner prays for sanction of family pension being differently abled son of the person or differently abled son whose father was working in BSF. Stop. In support of such contention, reliance is placed on disability certificate.
Lordship, I am confirming that his mother, Muktarani Gain, wife, was receiving the family pension. I confirm.
Yes. Disability certificate issued in 1998.
PPO number to Baba. No, we PPO the family pension.
Petitioner made an application. Petitioner made a representation dated 2nd April 2025 seeking family pension. And same is yet to be decided by the concerned authority of BSF. Next paragraph. Learned advocate representing BSF submits that as per norms, petitioner is required to submit application seeking sanction of family pension in prescribed pro forma. Stop. Since representation of the petitioner was not in prescribed pro forma, decision could not be taken. Stop. It is also submitted that mother of the petitioner was sanctioned family pension till her death on 1st November 2021. Stop. Next paragraph. In view of the respective submissions made on behalf of the parties, Pay and Accounts Officer, Central Pension Accounting Office, being respondent number 2, is directed to forward pro forma, prescribed pro forma, is directed to forward a pro forma by 10 days from the date of communication of this order in order to facilitate the petitioner to make application seeking family pension in the said pro forma. Stop. On receipt of pro forma, petitioner shall be at leave to make application, shall be at leave to make application in the said pro forma seeking sanction of family pension by fortnight thereafter. Stop.
Also, time may be increased because department will take some time.
By fortnight thereafter. Stop. If application is made by the petitioner in prescribed pro forma seeking family pension within the aforesaid time, comma, respondent number 2 shall decide the same in accordance with law, by 8 weeks thereafter, by 8 weeks from the date of receipt of such application. Stop. Decision to be taken by the respondent number 2 shall be communicated to the petitioner by 10 days thereafter. Stop. A writ petition stands disposed of.
I'm grateful to him.
Next.
Item number 86. I am for the applicant.
I am on behalf of Union of India. Yeah, Chitu. 86.
Oh, yes, sir. This is a matter regarding Malat.
You are for you are representing
Union of India.
But Union of India is not party.
Not answering party.
Union of India is not party.
Not answering party.
No, not a party. There are 3 respondents.
Yes.
State of West Bengal, then district magistrate and block development officer. Where is Union of India?
The different matter. Rajkumar. Number দেখে দিই Rajkumar কে দিয়ে different. This is a matter regarding
No, it's a 3rd May 2025 filing. When respondents are not represented, you have to serve notice again, because previous notice was relating to moving the writ petition before a different bench.
That is
issue. Affidavit of service. Have you filed affidavit of service?
Yes.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Respondents are not represented today. Next paragraph. Learned advocate representing the petitioner is directed to serve notice upon the respondents or the learned advocates representing the respondents, including copy of this order by.
Well, may I serve notice to the GP Malat, because I have already sent Malat GP to the send notice to GP Malat. By tomorrow I will.
By 10 days from date and file further affidavit of service on the next date. List the matter on hearing of this matter stands adjourned till 24th November 2020. Somebody must have been allotted from the panel. So you obtain to ascertain his name and send a notice.
So can we take it a Monday, Malat?
Next.
Item number 87.
The petitioner before your lordship is a retired employee of SPMICL.
Retired employee of
SPMICL, earlier it was India Government Mint.
Government Mint. Yes. SPMICL.
Retired from service on 1st October 2023.
Yes. Retired employee. When retired?
1st September 2023.
1st September 23.
And the effect of 7th pay commission was given from 1st January 2016.
1st January 2016.
As such, the petitioner was entitled to the overtime allowance, and that overtime allowance was given in the month of August 2024.
Government Mint petitioner is not required to approach tribunal.
Previously, it was different. Government of India. Now it has become a PSP.
There is no such notification under section 14(3).
So far.
Yes.
The overtime allowance, which was due from 1st January 2016 due to the implementation of the 7th pay commission, the amount was given to the petitioner in the month of August 2024. As such, and
you are seeking interest
and the other part, production incentive area. That
and
production incentive area from 1st January 2016.
That is payable to the petitioner in terms of 7th pay commission recommendation.
Yes, madam. He made a representation to the respondent.
When this overtime
benefit was paid after a period of 7 years.
In August 2024, overtime allowance was
given, but
which was required to be extended in favor of the petitioner on and from 1st of January 2016.
He made a representation to the respondent number 2, and by reply.
So it was after retirement, it was paid. Now your pension was consolidated in terms of 7th pay commission recommendations. But you are seeking interest on overtime allowance.
Overtime allowance and the production incentive allowance that was not given, and made representation to the respondent number 2.
Representation page 26.
Representation page 26, and they have given a reply that respondent number
First
2
reply.
is not responsible or the authority. Made a representation to the respondent number 1, that is the chairman. He also made a representation which is at
Page 29.
29. After that, they have written, they have given their reply,
31.
page number 31, and they have rejected the claim. Well, kindly come to paragraph 2 of the said letter, page number 31. Further, SPMCIL Corporate Office by letter number such and such requested to Department of Economic Affairs to clarify the request of the unions for extending the benefit of OTA areas, that means overtime allowance, as per 7th Pay Commission from 1st January 2016 to 30th June 2017 is tenable, whereas Ministry of Personnel, Public Grievance and Pension DOPT guidelines such and such dated ato stipulates for payment of overtime allowance as per ato, but the remains
Stipulates for payment of overtime allowance as per 7th Pay Commission from 1st of July 2017.
I am also claiming that period also.
No, you are claiming prior to that.
Just a minute.
Prior to that also, I have been
Just
paid,
a
but
minute. Wait. From 1st of January, 1st of July 2017, you have received.
yes, overtime allowance I have received, but they have not paid interest for 7 years. Because there's and
No, there are two periods which are considered by the deputy manager HR.
And the other part is
Here this court, why you are in such a hurry? There are two periods which are considered by deputy manager as it emanates from page 31. It appears that it is stated in paragraph 12, C paragraph 12, is tenable where Ministry of Personnel, Public Grievance and Pension DOPT guidelines number so and so dated 9 June 2018 stipulates for payment of overtime allowance as per 7th Pay Commission from 1st of July 2017. But before that it is written that they requested to Department of Economic Affairs to clarify the request of the unions for extending the benefit of overtime arrears as per 7th Pay Commission from 1st of January 2016 to 30th June 2017. Now question, so there are two periods. One is from 1st of January 2016 to 30th June 2017. Another is from 1st of July 2017 onwards. Now I am asking you that so far 1st of January 2016 to 30th June 2017, that part is disputed. But from 1st of July 2017, it is admitted. So 1st of July 2017 onwards, you have received overtime allowance within time, or in 2024 you have received it.
But you kindly come to the
Just a minute, please.
page 15 is the reply. He himself has given page 15.
1.5.
Oh.
1.5.
But that was stopped afterwards, 1/7/2017.
Then in 2024, what was paid to you?
2024, the benefit of overtime allowance which was due from 1st January 2016 up, was paid without any interest, that is after a period of 7 years.
So from 1st January 2016, it was paid.
It was paid, but without any interest after a period of 7 years.
You are referring to page 15.
15 is the calculation and 16 is the pay slip, which will. And
incentive area is different thing.
Different thing. Lordship. Now, what his thing is, there was no direction upon me to pay it. Moment the ministry gave us direction, we paid. Now he said,
no, if entitlement accrues in terms of 7th pay commission recommendation,
no, it was not
from 1st of July,
that
from 1st of January 2016, then he is entitled to get interest.
The Lordship, for that, Lordship,
it is a case that petitioner was subsequently became eligible to get
ministry
to get overtime allowance from 1st of January 2016.
Yes, Lordship, ministry previously when he was retiring, ministry had no direction upon me. Now after his retirement, like from different means throughout the country, there was a several representation to the ministry. That time it was a ministry. Then Lordship, it became a PSU, 100% owned PSU by the government. Then based on those, then the ministry clarify, yes, as an ex-gratia, you leave those. Moment we receive that instruction, means for the change of law, we are paying.
For understanding of PSU, why petitioner will
no,
suffer?
Not understanding. It's
for lack of understanding why petitioner will suffer.
Policy. Policy was not there to pay.
Only query is this in terms of 7th pay commission recommendation.
Whether 7th pay commissioner, I'm sorry.
Whether petitioner was entitled to receive overtime allowance from 1st of January, revised overtime allowance from 1st of January 20.
Initially, he was not. He was not. So calculation was made as per that.
How subsequently
based
on which clarification?
Based on the Government of India clarification, if your Lordship kindly turn to page 32. Page 32.
Please show me the 7th pay commission recommendation relevant part.
Lordship, that is, they have annexed part of it at page 33. But Lordship kindly, if your Lordship kindly turn to page 32. If your Lordship.
Last paragraph of page 31.
Lordship kindly see.
They have stated that the corporate office by letter dated 23rd April 2024 issued direction for payment of overtime allowance area to all eligible employees from 1st January 2016 to 30th June 17 covered under the provision. That is their part.
So Lordship,
they directed later on. Why should I suffer?
No, you demonstrate that you were eligible to get overtime allowance from 1st of January 2016
on the date of
1st of January 2016 based on 7th pay commission recommendation, which is at page 33.
I have annexed some pay slips.
Pay slip is your.
No, it will come later. From 1st of January 2016, you are eligible to, or you were eligible to get overtime allowance in terms of 7th pay commission. You demonstrated it.
Page 16 onwards, I have annexed.
So page 33. Page
33, they have written
fixation of revised pay and payments of arrears.
Page 33.
Page 33.
The letter they have given on 23rd of April 2014.
Page 32.
Page 32. Page 32.
Lordship, he has a justice demand. Should we give him a hearing and explain the accounts to him?
But it says paragraph 3, page 33, revised pay structure effective from 1st January 2016.
Yes, but
So therefore,
we have
revised-
given area.
Therefore, this overtime allowance needs to be extended from 1st of January 2016. Why it was
ex gratia, because everyone returned in 2016-17. Then they all returned in the 6th pay commission, Lordship. Kindly see. So the language is 6th, whoever enjoyed benefit under 6th, we will give them in 7th pay commission. It's a policy decision taken by the ministry. Lordship, can I do one thing, Lordship? Lordship, he has given me a justice demand. Should I give him a hearing and explain the thing to him?
So it is a case of revision of overtime allowance under 7th, because you are receiving overtime allowance in terms of 6th pay commission.
Yes, my lord.
So that revision took place from 1st of January 2016. So on revised overtime allowance, you are seeking interest.
Retrospective interest.
For a moment,
Come
madam.
to page 32.
Yes, I'm there. Lordship, kindly see.
It's a corporate office, and I am directed to convey the approval of the competent authority for payment of overtime allowance area to all eligible employees from 1st of January 2016.
So we were giving 7th pay commission from a retrospective effect. So now
why? Because seventh pay commission came into effect from 1st of January 2016.
No.
Why retrospective effect?
This pay commissions comes in a date with a retrospective effect from a date.
Yes.
So, Lordship, for the purpose
when the 7th pay commission was recommendation was issued.
Exact date I am not aware, Lordship.
Tell me the exact date.
No, Lordship, what I am saying is the principle.
No, if you say that suppose 7th pay commission recommendation was issued in 2020, in that event, there was no scope for granting benefit on and from 1st of January 2016 from the very next date, subsequent to 1st of January 2016. So because if it was if recommendation was issued in 2020, so that's why it is important when 7th pay commission
I will come back with that. Lordship,
often instruction comes.
What I am only was saying, if a date is given for a retrospective payment, most of the cases, because the pay commission comes on a date and then we say it will be date. So whenever it is given a retrospective date, but on the date when it is published, we are paying it immediately.
No, if
with retrospective areas.
If you submit that if it is a case of retrospectively given effect to the benefit of 7th pay
and
commission.
he is saying, since you are giving retrospectively, so
but
you
that
give the
should not
interest
be-
on that.
That should not be based on this later dated 23rd of April 2024. That should
No,
be
Lordship,
based on
19th
the
of
issuance date of issuing 7th pay commission recommendation.
No, Lordship, now
If it is found that much after 1st of January 2016, 7th pay commission recommendation was issued, then it was not within the domain of the respondent authority to release the benefit under 7th pay commission recommendation within time. So therefore, there is a justification to the extent. So are you in a position to inform to apprise this court that
right
when
now.
the 7th pay commission recommendation was issued?
No, Lordship, no, I am not.
Come
I will
back.
come back.
Come back.
But what I am saying, Lordship, one issue I was saying just, Lordship, since he has
Petitioner is
made,
a retired employee of India Government Mint.
Yes.
Now it is SPMCIL. Earlier it was India Government Mint.
Where is the nomenclature?
Lordship, now we are Security Printing and Minting Corporation of India.
Limited.
Yes. Petitioner was an employee of Security Printing and Minting Corporation of India Limited, who retired on superannuation on 1st of September 2023. It is submitted on behalf of the petitioner that in terms of 7th Pay Commission recommendation, revised overtime allowance was paid to the petitioner in the month of August 2024, and petitioner is claiming interest on revised interest on arrears accrued due to revision of overtime allowance with effect from 1st of January 2016 as per 7th Pay Commission recommendation. Mr. Banerjee, learned advocate representing Security Printing and Minting Corporation of India Limited, submits that retrospective effect was given based on 7th Pay Commission recommendation in extending the benefit of overtime, revised overtime allowance. On query being posed to the learned advocates representing the parties as to the date of issuance of 7th Pay Commission recommendation, accommodation is paid for to obtain instruction in order to apprise this court the date of 7th Pay Commission recommendation. Next slide. Hearing of this matter stands adjourned, which would enable the learned advocate representing the state respondent authority to obtain instructions. Please stop. Hearing of this matter stands adjourned till
Except 17th and 18th.
Yes. Till 24th November 2020. Affidavit of service filed on behalf of the petitioner. It is retrospectively given. Then there is a clarification.
Yes, retrospectively given, and
but in that event, I am telling you,
Commission
if it is from
binds me.
2020, suppose if it is from 1st of August 2020 is the date for issuance of recommendation under 7th
and
Pay
I
Commission.
paid him 24. Then I am liable.
Then
for that
you are
period.
entitled. Then he is entitled to get the interest from the next day, from the very next day.
Certainly.
Yes.
Because I have to be at fault. When I am supposed to pay, I am not paying.
Yes.
I am at fault, so I am paying the interest.
Come back obtaining instruction.
Sure. But Lordship, another thing issue in
Next
this,
matter. No, another thing today.
Item number 88.
88, my lord, Mr. Partho was appearing for the petitioner, your lordship. Lordship,
Who is appearing?
Mr. Partho Ghosh, your lordship.
Yes.
He engaged in courtroom number 13, your lordship.
Not today.
My lord, I am appearing for the
No
respondent.
order is passed. Not today.
Thank you, my lord.
Not passed. Yeah.
Item
Not
number
today, not
89.
today.
I am appearing on behalf of the respondents.
Who is appearing for the petitioner? You are for the petitioner?
90. Item number
89. You are representing Union of India.
Oh.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Mr. Bagh, learned senior advocate, represents respondents. Next paragraph. In order to grant one more chance to the petitioner, hearing of this matter stands adjourned till 24th November 2025. Next.
Item number 90.
90, may I please, Lordship, I am for the petitioner. This is my affidavit of service.
And the respondent.
What happened in this matter? My candidature was rejected on the ground of shortfall of height. So, Lordship, pass an order, interim order. My Lord, that order was confirmed by the another division, another coordinate bench. My Lord Justice Arindam Mukherjee. They preferred appeal to that order. Appeal confirmed the order passed by the learned single bench. Thereafter, they preferred SLP. SLP dismissed. My Lord, I am the petitioner before your Lordships. Pass an order following that order passed by the coordinate bench by my Lord Justice Arindam Mukherjee. I participate they have allowed me to participate the next my Lord, the PET. I passed, medically fit. Then they have put me in the withheld list without assigning any reason. In the result,
Constable GD.
For the year 2020.
Why petitioner was placed in the list of withheld candidates?
Your Lordship, as this brief is newly allotted, Your Lordship, I had a word with the respondents.
But this writ petition was filed on 8 May. Yes, you had
Yes,
what?
Your Lordship, one appeal has been filed which is pending before court number 4. My Lord Justice. My Lord Justice
Who has preferred appeal?
The respondent, CRPF. Your Lordship,
Not this matter.
the order they have challenged dated 5/12/2024, where the same petitioners have filed another writ petition related to this same grievances, Your Lordship. After disposal of that writ petition, CRPF has challenged that my Lord Justice.
But so far the case of the petitioner is concerned that the order of this court was affirmed right up to Honorable Supreme Court.
Lordship, Your Lordship.
No, not this order, my Lord, another similar type order that.
Similar type, absolutely, Your Lordship. Lordship, one direction may be given. We will file the affidavit or short report. Just
And
like
my Lord,
1 week time. I will
First.
give Your Lordship.
What appeal? What
They have
since
filed an
petitioner's name is appearing, petitioner qualified. Petitioner qualified in the test as well as in the physical measurement test.
Yes, medical test.
And medical test. So therefore, why petitioner's name petitioner was placed in the list of withheld candidates?
Your Lordship, there is an issue with their height.
What issue?
Your Lordship, it's annexed in the documents.
You will get the height from the physical measurement report.
Yes,
Where
Your
is that?
Lordship.
Yes, Mr. Kundu, where is your report?
Yes, that is page, my Lord, 27. My Lord, not 27. My Lord, starts from page 25. Firstly, rejected on the ground of shortfall of height. And in appeal, they have been rejected on shortfall less in height. Page
25.
26. Page 26. Page 25 is my appeal.
Less in height. Yes.
Less in height. I preferred this writ application. My Lord, kindly come to page 29.
So what was the actual measurement?
Actual measurement was, my Lord, 169.8 centimeter. 169.8.
It's a fraction of 1 centimeter, and which is less than, which is in between 169.7 and 170. It needs to be ignored as per the guidelines.
Yes, my Lord.
Your Lordship, in page number 23 of the
Where is
petition.
169.7 is
Page
Measurement
23
is
of my
there.
writ application.
page 23.
23.
Yes, Your Lordship, in page number 23.
169.8.
Yes, Your Lordship.
It needs to be rounded up to next centimeter, higher centimeter.
Yes, Your Lordship.
There is a provision to that extent.
Your Lordship, one
And,
appeal is already pending. That is why, Your Lordship, their recruitment is withheld.
Very well, recruit him subject to the outcome of the appeal.
Your Lordship, kindly give. I am led by, in this case, by Mrs. Tibrewal, Your Lordship. She is out of station. I just need just 2 to 3 days, Your Lordship. I will
Not
bring
appearing
the,
in any matter.
Your Lordship, she.
Therefore, court will wait.
I am undertaking, Your Lordship. I will give a short report in
filed
this
on 8
case.
May 2025.
Yes, and what happened?
Yes, I need
Is the
3
petitioner
days,
is
Your
First of
Lordship.
all, there is a provision that if it is 169.5
5 and more. it should
5
be.
or 16 or in between 169.1 and 169.5, it is to be rounded off to the next higher centimeter, that is 170. And if it is in between 169.7 and 169.9, then it is to be ignored. That is your own
Lordship,
provision.
In this case, the respondent have not done any
So
injustice.
why
as
that
they have
that provision was not applied?
Lordship, that's why
And
it is kept
petitioner was
withheld, Your
wrongly
Lordship.
placed in the list of withheld candidates.
Lordship, it is withheld. Their recruitment is not yet, Your Lordship, rejected. Just give me one opportunity, very short time, Your Lordship. We will file a short report.
No
in this
report,
case.
file and obtain an instruction and come back.
Yes, give me short time, Your Lordship. I will obtain it.
But already you have an instruction that due to pendency of the appeal,
Your Lordship,
he has been
just
placed
now
in the
I came to
list
know
of
from
withheld
the
candidates.
respondents, Your Lordship. Just now they came today and they just informed they need 1 or 2 days. They will bring all the instructions, everything, Your Lordship. Kindly, Your Lordship, consider.
Case 29, earlier readings.
It is CRPF.
Yes. Nodal agency was CRPF.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner participated in the selection process for being appointed as constable within bracket GD in discipline force,
94
and
95
selection process was conducted by the concerned authority of CRPF.
No, my lord, the selection process is conducted by the SSC, Staff Selection Commission. And the nodal agency conducted the PST, PET and medical.
Now, দরকার in discipline force, stop. In physical measurement, height of the petitioner was measured as 169.8 centimeters. And it is submitted that in terms of relevant norms, 0.2 centimeter needs to be ignored in order to declare the petitioner eligible in terms of height for being appointed as constable GD. Next paragraph, lawyer and advocate representing respondents has prayed for accommodation to file a report as to why petitioner has been placed in the list of withheld candidates. Stop. Who will file report? Director General, Central Reserve Police Force.
Police Force to আমাদের CRPF report কে file করবে আমাদের?
My lord, the SSC published the results. So SSC can only get like
Staff Selection Commission.
Staff Selection.
Concerned authority of Staff Selection Commission, being respondent numbers 1 and 2, is directed to file a report disclosing as to why till date petitioner has not been appointed as constable GD. Stop. Let such report be filed by 10 days from date. Stop. Hearing of this matter stands adjourned till November 2025. Next. Bring Mr. Kundu, bring these norms. There is a guideline 169.5, 169.7.
91, my lord, I am for the respondent bank.
Item number 91.
I am for the respondent bank.
Yes. You are for the petitioner?
Petition. Affidavit of service.
You are for Mr. Ghoshal?
Respondent bank, my lord.
Respondent bank.
My lord.
Issue is
Yes.
the subject matter of challenge in this petition is the non-payment of.
Now, Grameen Bank still exists or there is merger?
Merger, my lord, amalgamation took place, my lord, and now is one state, one Grameen Bank. Now it is West Bengal Grameen Bank. Previously, there are 3 Grameen Banks, my lord. Now one Grameen Bank.
No, but the only respondent is West Bengal Grameen Bank.
Yes, well, West
There is
Bengal
no
Bank.
problem. Yes. Yes, yes.
And kindly have a look, page 28. This is
Page
28. This is the subject matter of challenge. Letter was addressed to the petitioner.
It is not a case of special condition. It is not a case of special condition as contemplated under Rule 29, Regulation 29.
Fact remains, my lord.
You are dismissed from service.
Removal from service. Removal.
Yes, that also removal is also covered by Regulation 29.
My lord. Initially, the date of effect, the regulation was the date of effect was 1st April 2018. And clause 29, kindly have a look at clause 29. Although it has been mentioned in the regulation itself, my lord, page 28.
Yes, page 28. I am on page 28. An employee who is dismissed or removed or terminated from service shall forfeit his pension. And that is the general rule. In every rules, you will get the parameteria provision.
Provided that the authority higher than the authority competent to dismiss or remove or terminate him from service, if such dismissal removal term is on or after effective date. On or after effective date. Initially, the effective date was 1st April 2018. The pension regulation was amended, and the effective date, my lord, effective date was 1st April 1993. Page 25.
Just a minute.
1st November 1993. Page 25.
Just a minute. Terminate him from service. Only consideration as to the extent whether it is a special case, can be made by the higher authority if it is after the effective date.
The case is deserving of special condition. Is on.
No, first come to page 28. It says, provided that the authority higher than the authority competent to dismiss or remove or terminate him from service may, that higher authority than the disciplinary authority may, if such dismissal, removal, termination is on or after the effective date, that is the effective date of regulations 2018.
Effective date of initially effective date was 1st April 2018.
When this 2018 regulations came into effect.
1st April 2018.
18.
And
So such dismissal, removal, termination is on or after the effective date, that is after 1st of April 2018.
In this
And the case is deserving a special special condition.
In this case,
So is it your case that this removal was made after 1st of April 2018?
Initially, petitioner was terminated, removed from service by virtue of an order 19 December 2014.
19 December?
19 December 2014. Thereafter, he preferred an appeal on 3rd of February 2015. Appellate authority affirmed the order of the disciplinary authority. So, since it was not on or before the regulation, after the regulation, so he did not make any application for special case. Thereafter, the pension regulation was amended, and kindly have a look, page 25, first day of
But
November
how?
9.
Yes, page 25.
Page 25, regulation 2. This was amended. And may I read? May I read? Yes, may I read?
Just no, it's not required. You are relying upon amended regulation 2.
First day of April 2018, the figure, letters, and words.
Just a minute. To 1st day of April 1993.
First day of April 1993.
Yes.
First day of November 1993.
First day of November 1993. Instead of 1st day of April 1993. Instead of 1st day of April 2018. First day of November 1993. Yes.
In that day he was in service. Termination after the effective date. So he is entitled for the compensatory pension, my lord, in terms of the regulation.
Why?
But in terms of...
Let us read page 28 again. Place it. Rule 29.
Page 20, compassionate allowance. 1. An employee who is dismissed or removed or terminated from service shall forfeit his pension, provided that the authority higher than the authority competent to dismiss or remove or terminate him from service may, if such dismissal, removal, or termination is on or after the effective date, and that is 1st November 1993. Yes. 1993, yes. And the case is deserving a special condition. So why the case of the petitioner is not deserving as a special condition in the letter of rejection, that has not been mentioned. It is my case. We kindly have a look, class, in view of the above. What's the reason? In view of the above, the regulation 29.
What are those special conditions are delineated in the rules? What are the special conditions are delineated in the rules? I am asking you.
The rule clearly speaks about that the special condition, a deserving of special condition. The case is why not deserving? No reason has been mentioned.
No.
Yes.
How you can demonstrate that special conditions need further elaboration? That must be based on regulation 2018. Now, if regulation 2018 is silent regarding special condition, and it is not defined in regulation 2018 or the amended regulations of 2024, in that event, it depends upon the consideration of the authority. Now, the authority says that in view of the above, as per the decision of the competent authority, the bank is not in a position to consider your prayer for pension compassionate allowance, since the appellate authority has not considered your case as special condition. So where is the wrong? Where will come at 2? Mr. Ghoshal, fine. Here at 2.
Once again, kindly
Continue
have
item
a
number
look to the
91.
page 28.
Page 28.
Page 28. Last paragraph.
Yes.
In view of the above, as per decision of the competent authority, the bank is not in a position to consider your prayer for pension compassionate allowance, since the appellate authority has not considered your case. But my humble submission is the reason is the heartbeat of a decision. Cryptic one. Competent, the decision of the competent authority. The bank is not in a position. And thereafter, since the appellate authority.
Yes, Mr. Ghoshal.
My lord, the appellate authority is the authority who removed him from the service by affirming.
No, he did not. Appellate authority did not remove. Appellate authority affirmed the order.
Affirm the order of the competent authority. And next, the decision of the competent authority is the trustee board order of the trustee board.
No, I want to know. There is a provision under Rule 29.
Yes.
That in normally that an employee who is dismissed or removed or terminated from shall forfeit his pension, provided that the authority higher than the authority competent to dismiss or remove or terminate him from service if such dismissal, removal, termination is on or after the effective date. Now the effective date is 29. Now after
1st November 1993.
93. Now
After the
thereafter it
amendment.
says effective date, and the case is deserving of special condition.
Now there is nothing.
What is special condition?
Nothing. Regulation is totally silent about the special condition.
Then you have to adjudicate these issues rationally.
My lord, this regulation, nothing says regarding the
You have to
special
apply
condition.
your mind.
Yes, my lord.
Not as per the ipse dixit of the authority.
Because my lord, I am bowed down before your lordship. I am getting the entire regulation, but there is nothing in the special condition.
Yes, if court proceeds on the premise that there is no, that this rule is, this regulation is silent with regard to special condition as the term used in regulation 29.
My lord.
Now if special condition is not defined in the regulation, then the authority has to consider it appropriately.
My lord.
Now the authority has decided that no, it is, since it is, yes, the case of the petitioner or removal was affirmed by the appellate authority, you are not entitled.
My lord, it is the view of the my lord that authority should give a illustration regarding the special.
Yes, where is the
condition?
Where is the
as there is nothing in the regulation, when the authority considers the case of the petitioner, authority should emphasis on the word special.
Now, what are those cases where pension has been sanctioned in spite of imposition of punishment as stated as provided in clause in regulation 29, and why petitioner is not entitled to get the benefit of this proviso to regulation 29?
As there is a regulation, they have mentioned, my lord, but the illustration is not
there.
given in this order.
Yes.
As they are as per the regulation, he is not entitled. They are totally written the regulation, but no illustration is given regarding the special condition.
Yes, why? Because if special rules is not defined, if special condition is not defined in the regulation, in that event, question comes up that in what in what are the cases where pension has been sanctioned in favor of retired employees who suffered order of punishment.
Well,
Now,
I
what
have
are
to take
those cases
instruction, my lord.
and why petitioner was found not fit to get the benefit of
Yes,
pension in terms of Rule 29(1)(2)?
Give me some time, my lord. I have specific instruction, my lord, I have taken from the
But your
authority.
instruction cannot improve this order.
No, my lord.
This order remains on record.
But regulation totally silent about the special condition. What are the conditions?
Let me set aside this order, and
My
I will
lord.
direct the chief manager to pass a detailed order giving reasons why the case of the petitioner is not considered in deciding the entitlement of the petitioner to get pension, it was not found that it is a case of special condition.
My lord. My lord, my submission is that, my lord, there is nothing, this special condition not totally silent regarding the regulation. There is no single word. What are the special
Then the
regulation?
discretion has to be exercised judiciously.
My lord.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner was an employee of Bongio Gramin Vikas Bank, within bracket hereinafter referred to as bank quote unquote close bracket, who suffered an order of removal from service. Stop. Petitioner preferred departmental appeal, questioning order of removal passed by the disciplinary authority of the bank, of the said bank, but the order of the disciplinary authority in appeal remained unaltered. Stop. Subsequently, petitioner made application for pension / compassionate allowance page 28 page / compassionate allowance, which was
First line, in terms of pension under BGP
No.
employees.
Yes, please take your seat. Which was spurned by the chief manager within bracket HR and trustee within bracket BGVB employee EMP full stop pension fund and trust close bracket. Being respondent, a close bracket full stop, now they being respondent number 4. Order being respondent number 4 by communication or by letter dated 4th December 2024. Stop. Said letter dated 4th December 2024 is questioned in this petition. Next paragraph, learned advocate representing the petitioner relies upon Rule 29 or Regulation 29 of Bongio Gramin Vikas Bank within bracket employees plural apostrophe close bracket pension regulations 2018 and Bongio Gramin Vikas Bank within bracket employees close bracket plural apostrophe close bracket pension then again bracket amendment close bracket regulations 2024. Stop. It is submitted albeit in term albeit referring to Rule 29 of said rules of said regulations, referring to Regulation 29 of said regulations of 2018, ওই 2018 এর পাশে herein after referred to as said regulations করবে। আর 90 ওই বঙ্গীয় গ্রামীণ বিকাশ পেনশন অ্যামেন্ডমেন্ট রেগুলেশনস 2024 herein after referred to as regulations of 2024। ঠিক আছে, কি বলছিলাম সেন্টেন্সটা? Said regulations albeit referring to of said regulations of 2018। না, ওটা তো উপরে করে দেবে বলেছি, বুঝতে পারলে না? উপরে যেটা বলেছি 28 পর্যন্ত স্টপ না। আমি প্রথমে যেখানে রেগুলেশন গুলো বলেছি সেখানে উইদিন ব্র্যাকেট সেড রেগুলেশনস অফ 2018 এন্ড সেড রেগুলেশনস অফ 2024 করে দেবে, বুঝতে পারলে না? এবার মাথায় গেল? এখানে নয়, নাহলে বারবার ওই রেগুলেশনটাকে কোট করে যেতে হবে। সেটাকে অ্যাভয়েড করার জন্য উপরে বলেছি যে উইদিন ব্র্যাকেট, যেখানে ফার্স্ট আমি রেগুলেশন 2018 বললাম, সেখানে উইদিন ব্র্যাকেট সেড রেগুলেশনস অফ 2018 হিয়ারিন আফটার রেফার টু এ সেড রেগুলেশনস অফ 2018 আর হিয়ারিন আফটার রেফার টু দ্য সেড রেগুলেশনস অফ 2024। মাথায় গেল? এবার লাস্ট সেন্টেন্সটা পড়ো। Prayer of the petitioner for sanction of pension/compassionate allowance was refused as concerned as concerned authority of said bank did not find special condition, did not find existence of special condition। স্পেশাল কন্ডিশনটা কোট আনকোট করে দেবে। as provided under regulation 29 within bracket 1 within bracket Roman small 1। According to the petitioner, no cogent reasons no cogent reason is assigned, while inferring that it is not a case of presence of special condition, quote unquote, special condition, quote unquote। It is further contended as per said regulation 29 or as per regulation 29 within bracket 1 within bracket Roman small 1, an employee who suffered order of dismissal, removal or termination after effective date, quote unquote, effective date, may apply for sanction of pension and pension slash compassionate allowance and effective date, quote unquote, needs to be construed first day of needs to be construed 1st November 1993 in terms of regulation 2 of the said regulations of 2024. The prayer is made for setting aside of impugned letter dated 4th December 2024 of the respondent number 4 and sanction of pension slash compassionate allowance in terms of Rule 29 of the said regulations of 2018. Next paragraph, learned advocate representing said bank on virtual mode submits in terms of said regulations of 2024 effective date, quote unquote, is 1st November 1993. Stop. Effective date, quote unquote, is 1st November 1993. Stop. However, it is submitted special condition, quote unquote. However, it is submitted, the expression special condition, quote unquote, used in regulation 29 within bracket 1 within bracket Roman small 1 is not defined in said regulations of 2018. Therefore, it depends upon the decision of the concerned bank authority whether employee who suffered punishment of dismissal, dismissal or removal or termination is entitled to receive pension slash compassionate allowance or not. It is further it is also contended that as the bank authority, it is further contended as respondent number 4 found order of dismissal was affirmed by the appellate authority. Respondent number 4 found it fit not to grant pension slash compassionate allowance. Next paragraph. At first blush, order dated 4th December 2024 of the respondent number 4 appears to be cryptic, stop. in the event the connotation special condition quote unquote remains undefined in said regulations of 2018. Concerned authority of bank, while deciding application for sanction of pension made by the employee who suffered order of removal, order of dismissal or removal or termination, is required to apply his mind and to pass reasoned order. Stop. Such applications ought not to be negated mechanically. Stop. It is not disclosed in the order of the respondent number 4 that what are those cases where similar applications were allowed and benefit of Rule 29 was extended to the retired employees who are similarly circumstanced like the present petitioner. Stop. Next paragraph. In above conspectus, order dated 4th December 2024 of the respondent number 4 is set aside. Respondent number 4 is directed to revisit the issue by 6 weeks from the date of communication of this order and pass a reasoned order which is to be communicated to the petitioner by 10 days thereafter. Stop. It is open to the respondent number 4 to hear the petitioner before passing order. If respondent number finds it necessary. Stop. Writ petition stands disposed of at the end of the
File deeply obliged.
Rajan, hold on.
Item number 92.
92, Lordship, I beg to appear on behalf of the petitioner. The affidavit of service. Coal India against Coal India, my lord.
You are appearing for the petitioner, Mr. Chokri? Who is for the respondent?
My lord,
First time it is taken up 4th of May 2025 filing. Old service. Serve notice and come back. If affidavit of service filed on behalf of the petitioner is taken on record, stop. No one appears for the respondent, stop. Learned advocate for the petitioner is directed to serve notice upon the respondents or the learned advocates representing the respondents, enclosing copy of this order by 10 days from date and file affidavit of service on the next date. Hearing of this matter stands adjourned till 24th November 2020. Next.
Item number 93.
Yeah, for the petitioner. My affidavit of service.
Other side.
Well, I have served them long back. But it is with regard to the selection process.
Serve notice, whatever it may be, issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. In spite of service of notice, respondents are not represented. Next paragraph. Learned advocate for the petitioner is directed to serve notice enclosing copy of this order upon the respondents or the learned advocates representing the respondents by 10 days from date and file affidavit of service on the next date. Hearing of this matter stands adjourned till 24th November 2024. Serve upon the learned advocate, because once you have served, if you are aware of the name of the learned advocate, serve notice upon him.
Central government says they accept notice by the Ministry of Law, only the 11 standard.
No, but the allotment has been made in the meantime. So ascertain and serve notice upon the learned advocate.
94, 96.
Item number 94.
94, my lord. I am for the petitioner. This is my affidavit of service. My lord, here also the same thing is happened. My lord, I have
Item 90, like item 90, 94 to 96. 90, item number 90 was, my lord, the main petition, and these are the analogues.
Item number 19 was the main petitioner.
Yes, your lord.
And here?
And 94 to 96 are the analogues.
not analogous, my lord.
We have been instructed.
Matter relating to height.
Ministry, yes, your lordship. It relates to height, your lordship.
Yes, height. With
Where is the measurement?
yes, measurement, my lord, kindly come
Page-
to page 31 of my writ application.
31. Why, yes,
169.6.
yes, your
My
lord.
lord, thereafter I preferred writ application. This court allowed me to participate. I participate and medically declare fit, then put me in the withheld list. But
When I have fixed that matter?
Your lordship.
24th.
Yes, your lordship. And we have filed appeal also
My lord,
to all
in
these
this
matters.
In this matter
All.
only, I have received the copy of the.
You have filed appeal against
Appeal against the order dated 4/12/2024, your lordship.
passed by the coordinate bench.
Yes, your lordship. All the matters.
But you have
What
not
all
taken
the-
steps for hearing of the stay application.
Your lordship, it is going
What will be
on.
done? How long?
I am not appointed in those.
Next date, I will direct that subject to
Yes, your lordship.
outcome of the appeal, appoint.
I will comply, your lordship.
Yes.
Much of
By preferring an appeal, you cannot sit idle for 5 years.
No, your lordship, I
Issue.
undertake.
Obtain
Yes, your lord, I
instructions,
will
come
do
back.
it, yeah.
In that matter, I have directed to file a report.
Yes, your lordship.
By-
Within 10 days.
by respondent number 1 and
Yes, 1 and
They are
2.
same respondent, 1 and 2.
Yes, your lordship. Same.
Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner, next paragraph. Petitioner participated in the selection process for being appointed as Constable GD in discipline force. Stop. Petitioner, stop. It is submitted though petitioner qualified in the test as well as physical measurement. Name of the petitioner was included in the list of withheld candidates. Stop. Next paragraph on physical measurement. It was found that height of the petitioner is 169.6 and according to the petitioner as per norm 169.6
and 169.8.
It is-
Another is 169.8.
yes.
Two petitioners, my lord.
petitioners করবে তো height of the petitioners. One, what is the height of petitioner number 1?
169.6.
And what is the height
31.
of petitioner number 2?
169.8. Page number 34.
33.
45.
34.
40.
Height of কি বলছিলাম সেটা How height of the petition number 1 was 169 is 169.6 and height of petitioner number 2 is 169.8. Stop. Therefore, as per relevant norms, both the petitioners should have may be declared qualified for being appointed as constable GD. Next paragraph. Learned advocate representing respondents has prayed for accommodation to file a report. Next paragraph. Concerned authority of staff selection committee, staff selection commission of capital is directed to file a report by 10 days from date. Stop. List the matter under the same heading for further consideration on 24th. This matter will come up on 24th November 2025.
94 বলে দিন 94
Item number 95.
Your Lordship, same 95.
How many petitioners are there?
Here, my lord, one.
One.
Page.
Page, my lord.
Twenty-one, 169.6.
Page
21, 169.6.
page 21, page 169.6.
শোনো, দেখো সেম অর্ডার হবে, শুধু সিঙ্গেল পিটিশনার আর হাইটটা লিখে নাও 169.6. ঠিক আছে? ফাইল রিপোর্ট।
Item number 96.
96, my lord, same, my lord. Here, female candidate, here measurement was 156.6.
Page 21.
Page 21. Page 20.
21.
Yes, page 20.
What is the what is required height?
Required is 157 centimeter. For female candidate.
এসো ওখানে মেল ফিমেল দরকার নেই, যা আছে তাই 156.6 করে দেবে। আর কই রিকুইজিট ইয়ে বলেছি, হাইট কিছু বলেছি, 170 কিছু বলেছিলাম দেখো। না, ফাইল রিপোর্ট।
Much obliged.
Item number 97.
Well, I am for the state respondents in this matter.
Lordship, for the post of ASHA, I have appeared in the selection process.
Post of
ASHA, my lord. Accredited social health activist, my lord. I have appeared in the selection process.
Who is the appointing authority?
Appointing authority, my lord, BMH now. Block medical health officer, my lord.
Yes.
Lordship. Advertisement issued on 21st March 2023, my lord. Thereafter, I have appeared in the selection process, my lord. Admit card issued.
এই এসিটা বন্ধ করতে বলো না।
Thereafter, panel prepared. On RTI, I came to know that.
Yes.
On RTI application, I came to know that the panel prepared and my name appeared in the number 1 series, my lord, page 27, my lord.
For Asha.
Asha, my lord. And thereafter, I have made representation before the TM and CMH, my lord.
When the panel was prepared?
Panel prepared on, my lord, 15th April 2023, my lord. Till date, they have not taken any decision for a joint me.
15th April 2023 panel prepared.
I have made RTI application.
But you have filed this writ petition after the after 1 year.
I have made application page 30, my lord, RTI.
I am asking you,
Lordship.
whether still panel exists.
Lordship.
How do you know?
They have verbally
Generally, the life of the panel is 1 year.
Lordship, in between, my lord, they inquired into the sub-center, my lord, and thereafter, I have made RTI application. They have some document, my lord, and thereafter, I made representation, my lord, on 5th March 2024, my lord. But they have not taken any decision, my lord. Let them take instruction, my lord.
What is your prayer?
For appointment, my lord.
How do you come to know that you are impaneled
I have
candidate?
made RT application, my lord.
Yes.
They have.
Where is your RTA application?
Lordship, page 30, my lord. Page 30, I have inquired whether on 12 April 2023, Mamtaj
Just a minute.
Khatun, lordship.
Yes. Where is the response to this RTA application?
No, they have supplied the document page 27, my lord.
But no formal reply was given to this RTA application.
That I have not.
Yes.
Not annexed, my lord.
Yes, selected candidate as
Lord,
it
may I
appears.
submit one thing, my lord?
Why petitioner was not
That is-
engaged as Asha?
At the relevant point of time, my lord, 5 vacant sanction posts are there, my lord. But can you see the report of the National Health Mission, my lord?
No, I'm asking you simple thing. Interview was held.
Yes, my lord.
Petitioner was selected. Why she was
My
not
lord,
appointed?
my lord, it was wrongly advertised 6 posts instead of 5, my lord. Vacant sanction post was 5. But instead of 5, advertisement was published for 6th post, my lord. And the petitioner is the
Tell me who is
6th post.
working as Asha in Gram Panchayat Joypur Sub-Center Balkandi.
Well, that is vacant, my lord. No, that was not sanctioned post, my lord. That was not sanctioned. This is I am submitting the report, my lord. Can you see the report?
So if it is lying vacant, why petitioner will not be appointed?
My lord, no, that was not sanctioned, my lord. Not sanctioned at the relevant point of time. Can you see the report of the mission date? একটু দিন না just check. You know.
Now it is reported that there are 5 sanction posts
And that 5 approved.
but 6 posts were advertised.
Advertised.
Now, were those candidates who were appointed against 5 sanction posts?
But 5 candidates already appointed, my lord. They are working, my lord.
When they were appointed?
My lord, immediate thereafter, my lord, approval of the panel by the authority concerned, my lord.
Yes, when these 5 candidates against the 5 sanction posts were appointed.
September 23, my lord.
Why petitioner was left out?
My lord, there is,
Petitioner could have been considered against the 5 sanction posts instead of 6.
my lord, petitioner is the 6th position. My lord,
Where from you are saying it is not stated in the report that petitioner was allotted 6th position?
then may I file a report in the form of affidavit so that I can satisfy your lordship.
There are 5 sanction posts at the material point of time, but inadvertently 6 posts were advertised. Petitioner participated along with other candidates. Since there were 5 sanction posts, not 6, 5 candidates were appointed. Petitioner was one of the selected candidates. So why petitioner's candidature was not considered against one of those 5 sanction posts?
Well, here, the area-wise, Asha area, that is that 5 persons are
Do you
the...
have the copy of the report?
Yes, my lord.
Come to first paragraph of this report. In the instant matter, the instant matter is related to selection of Asha Kurmi in Bhalkandi sub-center under Joypur Gram Panchayat.
My lord.
That is the sub-center. Come to page 27 of the writ petition.
Bhalkandi, MS, my lord, kindly see.
No, Gram Panchayat, Joypur, sub-center Bhalkandi.
Well, Bhalkandi headquarters.
Now it says video advertisement so and so.
Well, may I submit one thing, my lord? Kindly see page 4, my lord.
At the time of advertisement, there were 5
Bhalkundi headquarters, HQ.
for the central hustle list of what
For different area, my lord, different persons are appointed, my lord. My lord, kindly see page 4, my lord, for a moment, my lord. Here, page 4. Top. Gram Panchayat Jaipur. Sub-center Bhalkundi HQ.
Yes.
These are different HQ and others are different area. So,
where are the particulars of appointed candidates?
Well, that was not in this.
Have you applied for the post of Asha in Bhalkandi headquarter?
Yes,
Lord,
my lord.
page 23, my lord.
So whether there are different zones?
Yes, my lord.
Under, just a minute. Under Joypur Gram Panchayat.
Lord, kindly come page 23, my lord. My application from Bhalkundi headquarter. Sub-center name Bhalkundi headquarter. Page 23, my lord.
Page 23.
My lord. Thereafter,
No, what I am asking you, yes, your application was for Joypur Bhalkandi headquarter. Now it is stated in the report that at the material point of time when you made application, there were 5 sanction posts, but inadvertently 6 posts were advertised. Now question is, if there were 5 sanction posts, whether these 5 sanction posts were for different areas?
Yes, but different mohalla, different area.
For different sub-centers, my lord.
For different sub-centers.
And this sub-center?
This sub-center is still vacant and I have applied for.
No, this sub-center is still vacant, you are correct.
Lordship.
But this sanction was accorded in after selection was made. It is stated that, but it is necessary to mention that at the time of advertisement, the newly won post was not sanctioned in the sanctioned list of Asha for 2022-2023. It was sanctioned in 2023-2024.
Lordship.
So if at the time when your candidature was considered, that was not against a sanctioned post, you have no right.
Since post facto approval may be given, sanction may be given, my lord. They have issued admit card.
That cannot be. On the date of your selection, there was no sanction post in Valkandi headquarter.
That is not my fault, my lord. I am the divorcee.
Yes, that is not your fault, but this has happened. We will file an affidavit.
My lord. Report in the form of affidavit.
Issue. Petitioner affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner offered candidature for being engaged as ASHA. ASH. ASHA Kurmi. Under Joypur Gram Panchayat, and subcenter was Bhalkandi, BHL KUNDI, HQ, headquarter, HQ. Stop. It is contended on behalf of the petitioner in reference to page 27 of the writ petition that petitioner was selected for the against the vacancy of ASHA under Valkandi HQ subcenter, but she was not favored with appointment. Petitioner, stop. Next paragraph, learned advocate representing the state respondents has filed a report of the program officer, National Health Mission and Joint Secretary to the Government of West Bengal Health and Family Welfare Department. Signed on 15th November 2025, and same is taken on record. It is disclosed in the report that in 2022-2023, when the selection process was initiated for engagement of ASHA Kurmi, post of or vacancy of ASHA under Joypur Gram Panchayat, Bhalkandi subcenter, Joypur Gram Panchayat, Bhalkandi HQ subcenter was not sanctioned, and said post was subsequently sanctioned in 2023-2024. Therefore, it is submitted that at the time when selection process was initiated for engagement of ASHA, where engagement of ASHA, it was not against the sanction post. Stop. Next paragraph. Issue needs to be decided on exchange of affidavits. Next paragraph. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
My lord, much obliged.
Next.
99 and 100 are similar matter, my lord.
How it can be similar? Because against one subcenter, one
can. May I submit one thing, my lord? In item number 100, my lord, subcenter are different, my lord.
No, this is item number 97. How similar matter against the same subcenter?
Different subcenter, my lord.
Different subcenter. Can you see the
and the post was not sanctioned?
Not sanctioned, my lord. Same, my lord. Identical.
This can happen without getting sanction of post. Why the authority initiated Selection process.
Can you see the report, my lord?
Advertisement, admit card issued, interview held, my lord. Panel prepared.
Yes.
99.
Subcenter Ishanpur, my lord. Gram Panchayat Parulia. These two are different.
আরে ফাইলটা দাও, রিট পিটিশনের কপিটা দাও, এই রিট পিটিশনের রেকর্ডটা দাও।
100.
তুমি শুধু রিপোর্টটা তুলে
হ্যাঁ না আমি 99 এ নেই।
ও
এই 99 আমি নেই তো, তাহলে হবে না। মানে
হ্যাঁ ডাকো,
আমি 90।
ডাকলে তো।
Item number 98.
I am for the petition.
90. This is the report in
100, my lord.
So it will be called on later.
Lordship.
Yes.
Lordship. Lordship, for the post of, my lord, data entry operator, my lord. From 2007, we have been working for the post, my lord. Thereafter, the authority concerned had issued, my lord.
You are for the state.
Yes, my lord, led by Mr. Yusuf, my lord.
Led by Mr.
KG Yusuf, my lord.
Where is he?
My lord, division bench, court number 4, my lord.
Not today. Apart from state, whether other respondents are there?
No.
No, my lord, they are challenging, my lord, the cancellation of the illegal promotion order of 2018, my lord, in the 2025, my lord. Kindly come to the page, my lord, 99, my lord. They are challenging this order, and my lord.
They'll come back tomorrow. Let me see.
Tomorrow.
Yes, my lord, 2018 order, my lord.
Not today.
Oh, great. My lord, paying for another thing, my lord. My lord, report, my lord, from the concerned authority not come yet, my lord.
Not required. Let me see. I have not called for any report.
Grateful, my grateful.
Item number 99.
Lordship, I am for the petition, my lord.
Lordship, I am appearing for the state in this matter.
Similar matter, my lord. Lordship, may I submit, my lord? For the post of Asa, sub-center, my lord, Jaipur, my lord. Page 22, sub-center is page 22, my lord, sub-center Jaipur, my lord. Here after panel, page 27.
It's Jaipur, sub-center Jaipur.
Lordship. Page 27, my lord.
Gram Panchayat Jaipur, sub-center Jaipur.
Lordship.
Yes.
Page 27 is the panel, my lord.
27.
Lordship.
Yes. You are not appointed. Yes. Why petitioner, in spite of being selected, was not engaged as Asha Kurmi?
Your Lordship, in this case, the report has not yet come. Your Lordship, this is hard to say why, because as per to the page 27.
Why report has not come? Matter was filed on 15th May 2025.
Yes, I have informed your Lordship to the concerned GP office regarding the same, but the report has not yet come. Lordship, kindly give me some time.
Selected candidate as it appears from page 27.
Yes, Your Lordship, I have seen that, Your Lordship. That's why I couldn't submit
So
now.
she should have been engaged as
Yes,
Asha.
Lordship, I was hearing the previous matters as well, and there, whatever foreign firm, Your Lordship, has heard. Your Lordship, my submission is that in this case, when the petition has been selected without the report, why the candidate has not yet been given any appointment, I cannot apprise the Lordship right now. Your Lordship, kindly give me or 1 week's time, I will come back with the report, Your Lordship. A preliminary report so that Your Lordship can derive what the reasoning for not being appointed till yet.
Will file report.
Your Lordship, I will
file report. Which authority will file? Which respondent will file report?
Your Lordship, the respondent authority will be the answering respondent will be.
Yes, tell me.
This one is subdivisional officer, my lord.
With the respondent number 3 is subdivision officer, Kandi office.
Advertisement was issued by the subdivision officer, my lord.
You have not added district program officer ICDS Murshidabad.
I have member secretary selection committee, I have made party, my lord. Advertisement issued, my lord.
Your Lordship, from page 24, it derives that this is the office of the subdivision officer of Kandi, subdivision Murshidabad. Page 24, Your Lordship.
SDO will file report in case of Asha.
Your Lordship, this is the office, the 24 says the office of the subdivision is there. Whether the members, the signature is of the member secretary, selection committee, Kandi subdivision office, Murshidabad.
Where from you are getting this?
Page 24, Your Lordship, of the writ petition.
Respondent number 4, my lord.
Or who will file? Issue. Petitioner participated in the selection, affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being engaged as Asha Kurmi under Joypur Gram Panchayat, Joypur Subcenter. Stop. In reference to page 27 of the writ petition, it is submitted on behalf of the petitioner that she was selected to be engaged as Asha Kurmi under the Asha Kurmi in the aforesaid subcenter. Stop. Since no engagement, since petitioner was not engaged in spite of being selected, prayer is made for necessary direction, which would permit the petitioner to be engaged as Asha. Next paragraph. Learned advocate representing the state respondents appears on virtual mode, who prays for accommodation to file a report. Next paragraph. Member secretary, selection committee and subdivisional officer Kandi, being respondent number 4, is directed to file a report in the form of affidavit by fortnight from date, disclosing as to why petitioner was not engaged as Asha in spite of being selected. Stop. A copy of the report shall be served upon the learned advocate representing the petitioner. Stop. Hearing of this matter stands adjourned till 27th November 2025.
Develop, Your Lordship.
Next.
Item number 100.
Lordship, this matter, my lord, page 25.
My lord, I am for the state respondents in this matter, my lord.
Shanpur.
My lord, kindly see the report, my lord. Here's 7th post declared, but sanction post was 6.
Where is the selection? Where is the document relating to your selection?
31, my lord, page 31.
Same advertisement paper.
Same, that
yes.
not against sanctioned vacancy.
Yes, my lord. 6 sanction posts are there, advertised on 7th. As such, 7th post was not approved by the authority, my lord, state authority, my lord. I can see page 4, my lord. Here's Sub-Center Ishanpur, Gram Panchayat, Parulia.
শোনো, ওই যে প্রথমে যেটা করা হলো না, ডিরেকশন ফর এফিডেভিট, ওইখানে চলে যা। স্যাংশন পোস্ট যখন নয় তখন সমস্যা আছে এফিডেভিটটি। তুমি চেঞ্জ যেটা করবে সেটা হলো রাইট, প্রথমে রিপোর্টটা দেখে নাও। রিপোর্টটা এটার ক্ষেত্রে ওই প্রোগ্রাম অফিসার, হ্যাঁ, ন্যাশনাল হেলথ মিশন, 10th November 2025, বুঝতে পেরেছো? 2020 সাইন্ড অন 10th November, টেকেন অন রেকর্ড করে দেবে। আর এখানে ওই গ্রাম পঞ্চায়েত পারুলিয়া, সাব সেন্টার ঈশানপুর। বলো বলো, হ্যাঁ, ওই সিলেকশনটা তো পেজ 31। আর কিছু পার্টিকুলার আছে দেখে নাও। হ্যাঁ, এটা সেম আছে। 2022, it was sanctioned in 2023, 2024. দেখে নাও। ডেট অফ অ্যাডভার্টাইজমেন্টটা দেখো তো, কিছু বলেছিলাম? Same order, direction for affidavit.
Yes, my lord. Same item number 97, my lord. Much.
Item number 101.
You are for the petitioner?
I'm for the petitioner.
I am appearing on behalf of state, my lord, led by Mr. Galib, my lord.
Only respondent is state?
No, my lord.
Lordship, I have served all. And
Union of India is
Union
there.
of India is there, my lord.
Lordship, Union of India is only a pro forma respondent.
No, problem is,
Nothing sought for against them.
problem is this, that this is an old service of 15th of May. Now, if respondents are not represented, I am giving a direction to serve it again. Because your previous notice indicated that it is to be moved before a different bench.
But they are supposed to keep vigil, your lordship. Your lordship, I tell your lordship.
No, I follow this system because this notice after change of determination gets diluted.
Lordship, then keep it next Monday. I'll serve it.
Yes, yes, I will retain. It will retain its position in the list. Main answering respondent is the state respondent.
Lordship.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. In spite of service of notice, respondent number 6 is not represented. Union of India being respondent number 6 is not represented. However, state
Lordship, Union of India, I think, could be deleted. There's no necessity. I think my junior has made a mistake.
If he wants to delete the
Lordship.
Very well. Place your case.
Lordship, the petitioner before your lordship is a deaf and dumb unmarried sister of a retired state government employee.
Deaf and dumb,
unmarried sister of a retired state government employee. Lordship, the employee, your lordship, all through his service career.
Where employee was working?
Lordship, he was
the fire department.
Fire department.
So you are not required to approach tribunal?
No, your lordship. No.
Yes, Mr. Gali.
But governed by WBA, sir.
But we don't have to, because your lordship, he's a retired employee, first of all. Second, your lordship, this is death pension. And your lordship, we don't have to go big. This is a matter, your lordship, where he's...
No, whether if the service is governed by WBA, sir, then you have to approach this tribunal.
Lordship.
Let us consider section 15 of the Tribunal Act.
Lordship.
Administrative Tribunal Act. এই দেখি ওই বইটা কোথায়?
The beneficiary under the West Bengal Health Scheme.
All service matters pertaining to service in connection with the affairs of the state.
Lordship, but this
Now, if any widow comes for payment of family pension in connection with the service of her husband, whose service was governed by WBSR, will approach High Court.
Lordship, in this case, we would. I'll come back to your Lordship. Can you take it up tomorrow? I'll come back. But I'll get the act with me and I'll satisfy your Lordship.
Take it. Read section 15. Suppose a case of compassionate appointment. Or family pension of widow. That widow will approach the High Court.
It has to go before the tribunal, Lordship. Section 15.
Because Miss Mukherjee, your right emanates from the service of your elder sister.
It emanates
Family pension.
Family pension, Lordship, rejection
Pensioner
by
died, family pension.
Yes.
Lordship, rejection by the accountant office of the accountant general. And your
Suppose any employee is working in Novanno. Now he dies. The wife will approach the High Court for family pension.
Lordship, I'll satisfy your Lordship. Just give me 1 minute. Lordship, section 15 says, A, recruitment and matters concerning recruitment to any civil service of the state or any civil post. This is not a
Civil
matter
post.
relating to recruitment. All service
Civil
matters concerning a person not being a
Civil
person
post.
Yes.
appointed to any civil service of the state or civil post under the state pertaining to the service of such person in connection with the affairs of the state or any local other authority. Lordship, the exception
No,
is in
if
clause
you
C.
submit that your service is not governed by the WBSR or you are not a state government employee, then I would consider not your service but a service of your elder sister. In that event, I will consider it. Is it your case, Ms. Mukherjee, that the service of your elder sister was not governed by WBSR?
Lordship, he was. But Lordship will see the exception made in subclause C. The exception in section 15 subclause C. Lordship will I'll read out section B1, section 15B. All service matters concerning a person not being a person referred to in clause C of this subsection or a member, person or civilian referred to in clause B of subsection 1 of section 14. So appointed to any civil service of the state or any civil post under the state and pertaining to service of such person in connection with the affairs of the state or any local or other authority under the control of the state government or any corporation. So Lordship, section C.
Clause C.
Clause C. Lordship, all service matters pertaining to service in connection with the affairs of the state concerning a person appointed to any service or post referred to in clause B, being a person whose services have been placed by any such local or other authority or corporation or any body as controlled or owned by the state government at the disposal of the state government for such appointment. The Lordship, he was an employee under the Department of Fire. And he was the fire services. Lordship, and he was not directly under the
Department of Fire is part and parcel of the state government.
And then your Lordship will kindly come.
Department of Health, Department of Fire, Department of Urban Development, all are part and parcel of the state government, Ms. Mukherjee. And your right to get family pension emanates from the service of your elder sister.
And para 3,
Your Lordship, I tell your Lordship. He has been, he retired, he had nominated her. And your Lordship, when an order has been passed, which is totally illegal and unjustified, relegating me to the tribunal, your Lordship, I would say at this stage would be not.
But our hands are tied.
Because your Lordship,
because it is not case, I have decided yesterday, it's not a case of alternative remedy. It is the case of only remedy.
Only remedy, Lordship.
In view of the law laid down in all L. Chandra Kumar.
Lordship.
It is a case of only remedy. If it is a case of alternative remedy, High Court has got a discretion or has got a power to decide whether it is an appropriate case to entertain the writ petition or not at this stage. But it is the only remedy available to the petitioner in terms of Section 15 of the Administrative Tribunal Act. In case of central government employee, it is Section 14. In case of state government employee, it is Section 15.
Lordship, this is not a matter relating to appointment. Lordship, Section 15.
You're right.
Lordship, Section 15 is save as otherwise, and your Lordship will kindly come. I'll take your Lordship to.
I am asking you, if a widow comes praying for sanction of family pension.
Kindly come to 3Q. 3Q is service matter means. Service matter in relation to a person means all matters relating to the conditions of his service in connection with the affairs of the union or state or local authority within the territory of India or under the control of the government of India, as the case may be, or controlled by the government as respects remuneration is clause 1, pension and other retirement benefits.
Matter ends.
And subclause 5 say any other matter whatsoever. This is the
definition clause.
Yes. 2Q. Sorry, 3Q. Sorry, 3.
Now only window which is left open if you argue that no, my elder sister's service is not a state government service.
Lordship, it was a government service. It was a government service.
Would you like to come back tomorrow?
Lordship, I would. I'll just come back tomorrow. I'll
Very well.
satisfy your Lordship. Because it is troubling my conscience, your Lordship. I'll come back tomorrow.
Lordship.
Not today.
Item number 102. I am for the petitioner. I have served. This is my affidavit of service. This matter pertaining to the petitioners belong to the scheduled tribe community, my lord, and a land loser category also, my lord.
এই এসিটাও কি বন্ধ করে দিয়েছো? অ্যাডভোকেটস আর সোয়েটিং, এটা চলছে তো?
Yes, my lord. Petitioner is the schedule type.
Is the other side.
I have served, my lord.
16th May 2025 filed.
Yes, lordship, let me say again, served, my lord.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. There are private respondents.
Yes.
Taken on record. Stop. Next paragraph. In spite of service of notice, respondents are not represented. Stop. Learned advocate for the petitioner is directed to serve notice. Learned advocate for the petitioners is directed to serve notice enclosing copy of this order by fortnight from date and file affidavit of service on the next date. List the matter under the same heading for further consideration in the monthly combined list of December 2025.
Item number 103.
I'm on behalf of the petitioner, my lord. The matter, my lord, becomes infructuous, my lord. The petitioner got employment.
Got employment? You are for the state. Issue. Learned advocate representing the petitioner submits. Grievance of the petitioner stands redressed. Petitioner has already been appointed. Next paragraph. State respondents are represented by learned advocate. Next paragraph. In view of aforesaid submission, no further order need be passed on this writ petition. Stop. Writ petition stands disposed of. Parties to act on the server copy. Next.
Item number 104.
In this matter, Mr. Margoob Salik is appearing for the petitioner, my lord.
Who?
He is on Margoob Salik.
Yes.
He's on leg, my lord. I'm praying for not today.
Not today.
Item number 105.
Yes, I am for the petitioner, my lord.
ফাইল করছেন আপনার কপি দিয়েছে all parties are present. Yes,
Report has been filed and we have filed after serving report by the state regarding the matters, and we have filed our exception today and affirmed long back, and
just a minute.
I have said. দরকার আমার তাই তো হ্যাঁ
By which order there was a direction to file report?
Yes, my lord, that is the order. My lord, I was directed to file a report 13th of June. 13th of June, it has been recorded that they have filed.
On the prayer of the learned state council, time to file report stands extended.
Thereafter on 13th
But 13 June. But prior to that, where is the order passed by the coordinate bench directing the respondent to file report?
That order is not there, but
yes. Where is such? But there is no such order.
No such order, and 13th of June, it has been recorded that the report filed in court today is taken up on record.
Please place your case. What is the matter about?
Matter about, my lord, my husband, husband of the petitioner number 1, he was working in the post of constable. He died during tenure of service. Then she applied.
Applied for
service on compassionate ground, and she was offered employment in Group D exempted category. Then she applied further that since my son, the petitioner number 2, is now major, kindly consider my health condition because I am suffering from heart problem. So it is better to offer the employment to my son. And that representation was time to time forwarded.
How this writ petition is maintainable before the High Court?
My lord, I have seen section 14.
How it is maintainable? You are holding a civil post?
Civil post. That is the point, my lord. I was thinking jurisdiction, power and authority of the central state administrative tribunal, section 15.
Yes.
Then, my lord, actually in their report they have said that the entire grievance.
Whatever may be the report, but this court cannot entertain the writ petition in view of section 15.
Section 15, I have checked. My lord, my respect.
You are holding a civil post.
Yes, police.
In police.
They are not denying. They are saying that is currently waiting for the approval of the government of West Bengal, the service of the petitioner number 2. Let them consider this, nothing more.
Whether I can entertain this writ petition?
I'm not asking for any direct appointment. Let them do this. That can be done.
My lord, on last occasion, I has raised this question, maintainability of the writ application, my lord, before your lordship. And this one is recorded by the coordinate bench, my lord, in the order sheet.
Recorded?
My lord. My lord, order dated 13th June 2025.
Yes, where it is recorded, in which paragraph?
Last paragraph. Second last paragraph. The respondents are taken out the point of the maintainability of the writ application, which is kept open and shall be heard first on the next.
Have you taken this point?
No.
My lord.
In the report, have you stated that
in report I have, what is the fact I have reported, my lord? But at the time of argument, I have raised the objection, my lord.
Rather, in the report, lordship kindly come to paragraph 12, that the decision regarding the appointment of Sandeepan Mondal, the petitioner.
But that does not confer jurisdiction of this court, whatever may be the contents of the report.
That I have understood.
By consent, jurisdiction is not conferred.
Conferred, but my lord, they have not taken specifically this point in the report. However, they are saying that it is under consideration. Let them consider.
Now you are working as?
No, I am not working.
Wife obtained?
No. She is also not working.
My lord, may I allow to make a submission, my lord?
She was offered in the group D post, exempted category. Then
In which department?
Police department.
Police department.
Then subsequently she said, by annexing the medical papers, that I am suffering from serious heart disease, kindly consider the appointment for my son, because now he is major. At the time of the death of the husband, he was minor. There was no scope to consider his appointment. Now I am saying that kindly consider the appointment of my son. And they are saying that they are considering this and
My lord,
waiting for the approval of the government.
In the year of 2018, petitioner number 1 applied on the ground of compensation ground, my lord, for employment. After 6 years, 10 days, once again she came before your lordship and filed the writ application.
In terms of the previous order passed by coordinate bench, report is
Report they have filed. I have filed the exception today.
By presenting this writ petition, inter alia, petitioners have prayed for appointment of petitioner number 2.
Yes.
Appointment of petitioner number 2, who is son of a deceased employee who died in harness while working.
He died on 27th of April 2018.
In Home Department, Government of West Bengal. Home Department within bracket police koro, Government of West Bengal. Stop. Stop. On perusal of the on hearing the learned advocates representing the parties, it appears that issue involved in this writ petition relates to appointment of petitioner number 2 on compassionate ground. Stop. since father of petitioner number 2 was state government employee, writ petition at this stage is not maintainable. Stop. Is not maintainable in terms of section 15 of the section 15 of the Administrative Tribunal Act 1985. So, hence, writ petition is dismissed. However, this order shall not preclude the petitioners to approach West Bengal Administrative Tribunal in pursuit of remedy on the self-same cause of action. Urgent Xerox certificate copy.
My lord.
All the points are kept moving.
Yes,
Yes.
I have granted you leave.
Your lordship has not entered into the merit of it.
I have passed order in my own way.
As your lordship.
On the self-same cause of action, I have stated.
Grateful, my lord.
Item number 106.
Yes, you are applying for the respondent.
This one.
At the time of call, no one appears for the petitioner, and no accommodation is paid for. Stop. Next paragraph. Union of India is represented by learned advocate. Next paragraph. In order to grant one more chance to the petitioner, hearing of this matter stands urgent. Stop. List the matter under the same heading on 27th November 2020.
I am not available due to personal reason, my lord. On first week of December, my lord.
List the matter on 20th November 2025. Next.
Item number 107.
In this matter, my lord, the affidavits that we have lost, my lord, they are appearing.
All parties are present. All the respondents are present.
The Union of
I'm for the Union of India.
they are the answering respondent.
No, state is
Yeah.
state is party. Director General of Police, Central Reserve Force. No, Central Reserve Force. Special
Yeah,
Director
yeah,
General of
represent-
Police, Central Reserve Force. Commander.
Yes, ma'am, they are represented.
Are you representing respondent number 1 to 4?
Lordship, all.
This is the second round of litigation, my lord. There is a
I think
provision.
third round. Third round.
There is a provision, my lord, under my lord, CCS pension rules that whoever my lord, dismissed or removed during service, my lord, for them, my lord, there is a provision under clause 41 my lord, for compassionate allowance. My lord, that must not be my lord, two-thirds of the more than two-thirds of the my lord, usual pension, my lord.
So the by order it has been turned down.
I have been granted 9,000 let. Let I have annexed few documents to show that this is for so that the basic livelihood I can let enjoy let. That's the purpose and object. Livelihood that I so that after termination of my service, so that I can survive with the basic livelihoods let. That's the object of the provisions let. They have given 9,000 let. But I have annexed few records, few notifications of the government let to demonstrate that a basic livelihood.
Where is the order?
Order is
granting
me
compensation.
Page 31.
Page 31. 31, yes.
এই এটা চালাও একটু গরম লাগছে হালকা করে চালাও এটা Yes. 9,000 is granted.
Now, my lord, page 29, if you kindly take some, my lord, once the relevant part only, my lord, the order, my lord.
What you are praying for?
My lord,
enhancement.
Enhancement. That should be the basic, my lord. Now, my lord, page 29.
29.
Yes, 29 was the conclusive part, findings of the committee, my lord. Now, my lord, last clause, clause 11, my lord. Kindly see, my lord, my admittedly dependent is 4.
Page 29.
Yes, my lord.
Yes, 29.
The number of dependent is 4, my lord. Only for this permanent. This is the order, my lord.
No,
Passed
page
the-
29, clause 11,
Clause
Roman 11.
Roman
yeah.
11, small Roman.
Yes.
I have shown this to demonstrate this is the consideration based on which the authority has drawn a conclusion in the next paragraph 9,000. Now, my lord, if you kindly takes up page 36. My lord, this is for the agricultural worker, my lord. Unskilled agriculture, the base price.
No, but what is the basis of prayer for enhancement of compensation? Compassionate allowance. Is there any circular that it can be enhanced further?
No.
Then
that's why, my lord, the entire purpose and object is to, my lord, give the basic. Now, my lord, page 36 is for, my lord, unskilled agricultural worker. The basic.
How that is applicable in this case?
My lord, this is the circular of the state under minimum wage act, my lord, that is applicable to all everybody, my lord.
No. The service of the petitioner was governed by the service rules of the department.
Yes.
Yes.
But the minimum wage act is, my lord, the enactment to ensure who are not in government employment, even for them, government is.
Please show me any document, any circular of the departmental circular by which it can be enhanced.
There is no, sir.
Not by inferential process of reasoning, Mr. Ahmed.
But I am on my constitution, my lord.
Yes.
Not
by inferential process of reasoning. You show me that you are entitled to get enhancement, that not 9,000 but 90,000.
May I
Yes.
pray for this, my lord? My lord, the authority must have certain, my lord, parameters to come at, my lord, 9,000, my lord. But they can, my lord, demonstrate before this court how come, my lord, they have drawn this conclusion of 9,000, my lord. Whereas, my lord, I have made a representation. That's why, my lord, I have made a representation to at page 34. That is, my lord, pending consideration by the authority, my lord. And my lord, that is based on this circular. They can come and say, no, these are my circular.
Whether the Payments of Wage Act applies in case of the petitioner.
That is the base price for.
I am asking you whether the Payment of Wages Act applies in case of the petitioner.
That Payment of Wages Act is not directly applicable to, but that is the minimum wage for every citizen of India. Government is not bound to, if the government is bound to ensure livelihood of all citizens of India, then somebody is not exploited in the agricultural field. Even for them, government has issued a notification under.
What is your instruction?
My lord, my instruction is that, my lord, the petitioner is caused a mutiny in. He's a CRP officer. He has caused a mutiny in his service area, that is in Kashmir, and he was, after, my lord, departmental inquiry, removed from his service. Last two set of applications before this Honorable High Court was challenging that removal of the service. In the last occasion, my lord, he totally abandoned that portion, and, my lord, at page 23, he entirely changed his argument and applied for, my lord, compassionate allowance as page 36 in the WP number 8460/2004. The compassionate allowance is entirely different.
In the first writ petition, order of removal, dismissal or removal?
Removal from
all for dismissal from
dismissal or removal?
He was removal from service. Removal service.
Yes, removal from that has been written in the reason decision itself.
Yes.
First, second line of the reason decision.
So in the first writ petition, the order of removal was challenged.
Challenged. On the both the.
Then what was the fate of the first writ petition?
My lord, in the first writ petition, my lord, the order is there. At page 18, there is a review application. The direction was given to complete the review application. After review application,
Review was rejected, and thereafter fresh read.
Second read was.
And in the second read, this order of consideration was passed.
And his penalty of removal from service was confirmed in that way.
In review.
Ultimately, he abandoned that right.
Where is Rule 41 of the Civil Service, Central Civil Service Pension Rules?
I don't have the entire cover of relevant rules, sir.
আপনাকে দিয়েছে রুলটা দিয়েছে
না
তাইনি না
এটা কি লেখা আছে কত
not exceeding 2/3 of pension or gratuity is the maximum limit.
not
What is the wrong in the order?
that's a higher limit
And it depends upon the circumstances.
and the parameters I can find from the rules that number of dependents etc has to be taken into consideration that is there in the rules
It's a special provision.
yes
Considering the conduct and the order of punishment, the authority takes decision.
only one thing that I just
And the provision is that provided that the authority competent to dismiss or remove him from service may, if the case is deserving of special consideration, sanction a compassionate allowance not exceeding 2/3 of pension or gratuity,
I have seen that.
or both, which would have been admissible to him if he had retired on superannuation pension.
May I propose this that today they have arrived at a decision that the issue I have raised in regard to the minimum wage and all this has not been taken because I have made a representative to them. Let them consider it. If I find that this is that they have giving after consideration.
No, Mr.
I don't mind if you don't pass any mandatory order.
Already on the prayer of the petitioner, representation was considered, whereby prayer was made for sanction of compassionate allowance.
Yes, I have seen.
And that has been allowed.
Allowed that only enhancement, that reason I have given. They may say, no, this is no reason. Let them take a decision that this is no reason. If it is enhancement, according to me, it would be 13,000. They may say, no, we are not entitled to 13,000. Let them decide about this. This much I'm paying. I believe this will not prejudice anybody.
File your affidavit, sir. I'm not impressed at all.
May I come back with authorities?
No. And your wages act does not apply.
If your lordship directs them to
in view of this rule 41.
if your directs them to consider and decide in the meantime, that if they
Provision for enhancement.
but this will not prejudice anybody, possibly.
Affidavit of service filed on behalf of
May
the
I take
petitioner.
leave?
Yes, yes. Affidavit of service filed on behalf of the petitioner is taken on.
My lord, the affidavit service, I lost it.
Get it out, right? Yes, submitted. Matter is heard in presence of the learned advocates representing the petitioner and respondent authorities. Stop. In the writ petition, order dated 18 November 2024, passed by Commandant -66 BN, money battalion, BN CRPF, is questioned as by said order, petitioner was sanctioned compassionate allowance, quote unquote, quote unquote, compassionate allowance to the tune of rupees 9,000. Now, compassionate allowance at the rate of rupees 9,000 per month with effect from 11th October 2024 in terms of Rule 41 of the Central Civil Service within bracket pension close bracket rules 2021. Stop. According to the petitioner, considering number of dependent family members, petitioner ought to have been sanctioned compassionate allowance at higher rate per month. Stop. Next paragraph. On perusal of Rule 41 of Central Civil Service within bracket pension close bracket rules 2021, it appears competent authority or authority competent to dismiss or remove a government servant from service may, if the case is deserving of special consideration, sanction a compassionate allowance not exceeding 2/3 of pension or gratuity or both, which would have been admissible to the government servant if he had retired on superannuation pension. Superannuation pension, দেখে নেবে এখানে এই জায়গাটা বেসিক্যালি বলে স্টপ next paragraph therefore prima facie it appears order passed by the concerned respondent authority dated 18 November 2024 is not contrary to said rule 41. Stop. Issue needs to be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next.
Item number 108.
Mapping for Public Service Commission.
All respondents are present.
Matter. Yes.
No, state government is party also.
I served all the respondents.
When served?
Deputy service is there.
When served? Find it out. Yes, you are appearing in this matter for the state.
Yes, Lordship, I am appearing for the state. I have asked for instruction, but the entire selection process has been conducted by the Public Service Commission. So department, the record is kept with them, Your Lordship.
Public Service Commission is represented.
Okay, yes.
Place your case.
Now, the very short prayer for consideration of the representation. Your things for a moment, paragraph 7 I've stated. In 2019, a process was initiated for fill-up of the post of supervisor of the supervisor.
Supervisor where? Supervisor?
Supervisor of a
ICDS.
This is ICDS supervisor, female Anganwadi worker and caseworkers.
the
It's
petitioner is
examination.
an Anganwadi worker, and the subsequently 2019 the advertisement was made that those who are working as a Anganwadi worker may apply for the post of supervisor.
Yes.
May apply for the post of supervisor.
Those who are working as
Anganwadi worker. My client is also working.
Anganwadi worker. Applied for the post of supervisor ICDS. Yes.
2019, a process was initiated. Now, since 2019, they are sitting tight over the matter. 2023, a publication has been made, the merit list. 2023. My client could not know when the matter published, but when the
Your client, petitioner, was not
aware.
included in the list.
So far, my client made the prayer. So far, merit list has been published, not considering the experience and not considering the qualification or the scoring marks. Not has been published in the published. So that my client made the application.
When the panel was prepared.
The panel was prepared long time back. Lordship, what is the status here? There are two types of examination: ICDS supervisor, one by direct recruitment and one by
Promotion.
That is department.
Petitioner is
Yes,
it comes under the
promotion.
head promotion.
Yes. So department issued the notification. Even the application forms were received by the department. We have just conducted the examination. Petitioner is a general category candidate who has obtained 137 marks out of 400. Whereas the last cutoff marks for qualifying to viva vice was 180. Therefore, she could not succeed. And Lordship, all the details of the marks of all successful candidates are published in the website, Commission's website on 12th April 2023. Lordship, I shall file a report.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner, being Anganwadi worker, participated in the selection process for being appointed as supervisor ICDS. Stop. Grievance of the petitioner is she was not impaneled for being appointed as supervisor, and submission is made. There are certain flaws in the selection process resulting in denial of right of the petitioner to be considered for appointment as supervisor. Next paragraph, state respondents and West Bengal Public Service Commission are represented by learned advocate. Learned advocate, stop. Learned advocate, stop. Next paragraph. On behalf of West Bengal State Public Service Commission, it is submitted that petitioner did not come within the zone of consideration, considering allotment of marks in favor of the petitioner. As a result whereof, her candidature could not be considered for appointment of supervisor ICDS. Stop. It is also submitted that petitioner obtained marks below the cut-off marks fixed under the category of the petitioner. Next paragraph. Concerned authority of Public Service West Bengal Public Service Commission is directed to file a report in the form of affidavit disclosing as to why petitioner could not be considered for appointment as supervisor ICDS by fortnight from date.
Grateful.
Stop. Copy of the report to be supplied to the learned advocate representing the petitioner. List the matter under the same heading for further consideration in the monthly combined list of December 2025.
Grateful, my lord.
আমাদের কপি দিবি অর্ডারে বলেছি নামটা দিয়ে দিবি হ্যাঁ দিয়ে দিবি
Item number 109.
Lord, I am appealing for the petition. Lord, on the earlier occasion, I was directed to serve notice upon all the respondents. Now, my lord, this is my affidavit of service.
Whether all the respondents are represented today?
No, my lord, only state, my lord. Here, my lord, illegal construction.
Just a minute. Just
For the illegal construction. No matter.
Illegal
State Transport Corporation, North Bengal, who is
North Bengal State Transport Corporation, my lord.
you are representing North Bengal State Transport Corporation?
No, my lord, state.
এটা কত নম্বর ম্যাটার তুমি দেখছো? আরে না, এটা অন্য ম্যাটার। তুমি ভুল করে অন্য ম্যাটারে চলে গেছো।
No, my lord. I am
দেখতে পাচ্ছি।
The service of 30th August 2025 notice service of notice dated 30th August. Now there is a change of determination.
Yes, my lord.
So you have to serve it. Nobody is representing. He is wrongly appearing.
Yes, my lord.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Respondents are not represented today. Next paragraph. Learned advocate for the petitioner is directed to serve notice enclosing copy of this order upon the respondents or the learned advocates representing the respondents by 10 days from date and file affidavit of service on the next date. File further affidavit of service on the next date. Next paragraph. Hearing of this matter stands adjourned till November 2025.
26 November. Yes.
By 10 days serve notice, file affidavit of service.
Yes.
Next.
Item number 110.
Appear for the respondent.
Your Lordship, I am appearing on behalf of the advocate record Chakraborty. He left the court due to some personal problems. He just
We
communicated.
are here up to 4:30 and advocate has left the court. Other side is learned advocate representing the
Personal
respondents are
problems, he
there.
just called for a not today, Your
And he merrily has left the court.
Over the phone, he's told me, Your Lordship, what I can do. Just
He
take
doesn't like to stay at court after 2 p.m.
for personal problems, family may matter, maybe. Just For urgency, he left, Your Lordship, not today, Your Lordship.
You will find somebody, some persons that they don't prefer to stay at court after 3:30.
Extremely regretted to that.
And that has happened actually. When he has come to court and was there up to first part of second half, why he has left the court?
I don't know, Your Lordship, for personal reasons.
Very well, I am imposing cost of 5,000 for adjourning the
No, Your
matter for
Lordship,
5 days.
kindly not today, Your Lordship. Regretting for
Other
that.
side is here. He is waiting for such a long time. Yes. It is as per sweet will of the learned advocate, instructing his friend to pray for time. I am leaving court. Not today.
In that moment, if your lordship is pleased to, my lord, make it not today, not tomorrow, my lord, day after.
You have difficulty?
Tomorrow.
Tomorrow.
Day after tomorrow.
Record an order. At the time of call, you are representing all the respondents. At the time of call, accommodation is paid for on behalf of the petitioner. Since learned advocate is not present in court. Next paragraph, respondents are represented by learned advocate. Next paragraph. Hearing of this matter stands adjourned till Monday next. 17 November 2020.
Item number 111.
My lord, this matter is exactly similar to item number 84, which my lord was pleased to fix it on Monday. Mr. Mukherjee is leading me. So my lord, let this matter be tagged so that the same issue is there in both the matters. We preferred an appeal, liberty granted, came back, file a modification application. So everything is.
What was the order passed in appeal?
My lord, the order that has been passed is, my lord, may kindly take my CAN application once, please. And it's at page 28. This is on the basis of Kusum Ignat's judgment.
Appeal is MAT 1222 of 2024.
No, my lord. Page 28.
Who preferred appeal?
To FMA 1235 and FMA 1239. CAN 1.
Yes.
CAN 1, page 28.
No. Whether the appeal, who preferred appeal?
Well,
Development officer or LIC?
LIC preferred an appeal.
LIC preferred appeal. But in the appeal, it was not MAT 1222 of 2024.
No, my lord, not MAT. My lord, CAN 1, my lord, may kindly take.
What was the order passed by
Well,
the
I'll just give you a very short background. The 2009 Development Officers Rules, which has subsequently been amended in 2016, has been assailed by the writ petitioner challenging the virus. Now, my lord, this challenging this virus, there are several writ petitions that were pending in all over India. One of such was initially decided in 2012 by Allahabad High Court, which went up in appeal in 2000 before the Supreme Court. Supreme Court upheld it. Similar order was another passed, which again went up in Supreme Court, and Supreme Court said that the issue was not entirely decided in 2012. Hence, I am remanding this matter back to Allahabad Court for a complete consideration. Ultimately, in December 2024, the Honorable Division Bench of Allahabad High Court has upheld the virus of these rules. Now, my lord, wherein against that an SLP was preferred, and that SLP is pending. However, the petitioners have not preferred any stay, neither any stay is granted. That is pending.
6366 of 2025.
Yes. So,
and it is fixed on 24th November.
24th November. Now, my lord, previously, when this matter came up, we took this point. However, the coordinate bench was of the view to pass an interim order whereby directed LIC not to take any final decision. However, to
proceed with the
yes.
I have also passed several orders.
So, being aggrieved by that order of the coordinate bench, we preferred an appeal before the Honorable Division Bench. Now, my lord, that order is at page 28.
Of your
of my CAN 1 application, because through which, my lord, liberty was granted to file this modification application. My lord, paragraph 3.
Just a minute.
CAN 1.
Huh? 30th June 2020. No.
18th August 2025.
Page
28, my lord. My lord, paragraph 3.
Just a minute. Yes.
So, my lord, on the basis of this liberty being granted, actually, my lord, what has fallen from the Honorable Division Bench is that in Kusum Ignat's judgment, the Honorable Supreme Court has already held that when a virus has been upheld, that becomes binding. So, court granted us the liberty that we should come back and file a modification application and place Kusum Ignat's judgment and argue on that line. On this basis, we withdrew the appeal, came back and filed this modification application. Similar application has been filed in item number 84, where Mr. Mukherjee is addressing. So, my lord has already fixed the matter on Monday. So, since the issues are same, let this be tagged on Monday. Let Mr. Mukherjee address, my lord, on this point. Because the issues are same, everything is same, he is addressing.
Yes, if you open up the case, then there will be difficulty. Since Mr. Mukherjee is appearing in
exactly, that is my prayer.
I will not tag that matter. I will place the matter after Monday.
Very well, my lord. As your lordship pleases.
Only thing which will trouble me is this: the pendency of the
My lord, but pendency
SLP.
With deepest of respect, my lord, pendency, my lord would see the order sheet. Order sheet.
Very.
On the last occasion,
Let
petitioner went
Mr.
and sought for
Mukherjee
time.
comes and argue, then I will.
Yes, my lord, we will.
Matter is heard in presence of the learned advocates representing the petitioner and Life Insurance Corporation of India. You are appealing for?
For Union of India.
Petitioner, representing the petitioner, Life Insurance Corporation of India and Union of India. Stop. An application being can 1 of 2025 is filed by LIC, by Life Insurance Corporation of India in terms of the leave granted by the Honorable Division Bench. Video order dated 18th August 2025, passed on two intra-court appeals. First one being FMA 1235 of 2025, within bracket, the managing director / chairman, Life Insurance Corporation of India and others versus Munmun Noskor and another, close bracket. Stop. Stop. Here, next paragraph. Hearing of this matter stands adjourned till November 2020.
My lord,
on 17th it is fixed.
Yes. So be just on 17th only let it wait as your lordship. My lord, the affidavit of service.
Yes. Affidavit of service filed on behalf of the applicants or affidavit of service filed on behalf of Life Insurance Corporation of India is retained on record.
I'm so grateful.
Item number 112.
112, my lord, I am for the petition.
Tomorrow.
Yes, sir.
The last occasion, my lord, it was fallen for from my lord that whether this matter will be taken up by this honorable court or the petitioner will have to approach the learned Central Administrative Tribunal.
Just a minute. All the respondents are represented.
I am representing respondent 3 to.
Who are respondent number 1 to 3? 1 and 2.
1 and 2 is the Union of India, and 5 and 6 is the Hindustan Steel Works Construction.
Where is the notification? Under section 14(3). So far, Hindustan Steel Works Construction Limited is concerned.
My lord.
Where is the notification under section 14(3) of the Administrative Tribunal Act 1985?
I am not carrying, my lord.
Why not? This is the relevant issue. Is there any notification issued on behalf of Hindustan or by the central government notifying or changing the schedule and including Hindustan Steelworks Construction Limited as one of the authorities in terms of section 14(2) and 14(3) of Administrative Tribunal Act 1985? That is the whole issue, because petitioner is employee of Hindustan Steelworks.
No, my lord, he had applied for the post of deputy manager in Hindustan Steel Works Corporation.
Then same thing, recruitment. Show me notification.
No, I have not carrying. I am not carrying.
In case of Steel Authority of India, there is a notification.
Kindly.
Tomorrow?
Okay.
Why not? Matter was last heard on 30th June 2025.
Kindly give me 1 week at least. 1 week. At least 1 week, my lord.
Next issue. Matter is taken up for consideration in presence of the learned advocates representing the petitioner and respondent number 3 to 6. Representing the petitioner and Hindustan Steel Works Construction Limited, being respondent number. National Building Construction is also part of Hindustan Steel Works. No?
Yes, my lord. It is under the Hindustan Steel Works.
You are representing 3 to 6.
I am representing, my lord, Hindustan Steel Works, my lord.
So what about 3 and 4? Why you have added National Building Construction and its chairman as respondent numbers 3 and 4?
The subsidiary of NBCC. Subsidiary of National Building Construction Corporation Limited.
Which authority is subsidiary to?
The Hindustan Steel Works Construction Limited is the subsidiary of the NBCC, the National Building Construction Corporation Limited.
So you are representing whom?
I am representing the National Building. That
you do not know whom you are representing.
It's a 5, my lord. 5, 6.
So what about National Building Construction and the chairman National Building Construction? Why in the previous order your name was recorded against 3 to 6? Sudeep Pal Choudhury?
My lord. On that day, my lord.
Yes. Why your name was incorporated or included, recorded in the cost title of the order against respondent numbers 3 to 6?
Because my lord, that is a subsidiary of the Hindustan Steel Works, subsidiary of the National Building.
Very good, but are you, if you are representing on behalf of respondent number 3 to 6, disclose this before this court.
My lord, I don't have.
Yes.
I don't have authority to. Right now, I have no authority. I have to.
Have you filed your Bhoganatnama?
Yes, department.
You have filed Bhoganatnama on behalf of for which respondents?
For Hindustan Steel Works.
Hindustan Steel Works. Not on behalf of respondent number 3 and 4.
My lord.
Where is your Vokalatma? Where is the entry number of Vokalatma?
I don't
Have
know,
you
my
filed your Vokalatnam or not? On which date you have filed your Vokalatnam?
I can't recall it, my lord.
Yes?
I cannot recall it, my lord.
You don't?
I cannot recall it when I filed, my lord.
When you have filed? But you have filed. Are you sure that you have filed it? Shall I
Check,
direct the department
check, my lord. I
to
check and-
place the Vokalatnama file?
I said check and state, my lord.
Not today.
Item number 113.
One on three, my lord, I am appealing for the petition.
I am for the respondent number 4.
My lord, as per direction in earlier occasion.
Just a minute. Wait. Notice. Who is representing 5 to 7?
But as per direction, my lord, I served 5 to 7.
When you have served?
My lord, a track report is there with copy of the order.
Lord, could I take a point which I took? This is an appealable order. Before the other judge, I have took that point. I have got
1st of July 2025 service. Serve again and come back. Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. In spite of service of notice. You are respondent number 4 and Mr. Dey state respondents.
Lordship.
In spite of service of notice.
I can also appear, no? District judge.
Order 5 to 7. Oh, district judge Purulia.
May appeal karo.
Respondent numbers 5 to 7 are not represented. Client advocate for the petitioner is directed to serve notice enclosing copy of this order upon respondent numbers 5 to 7 or the learned advocate representing those respondents by 10 days from date and file further affidavit of service on the next date. Next paragraph. List of matter under this. Hearing of this matter stands adjourned till 24th November 2024. You are for High Court administration. Next.
Item number 114.
Petition is directed against the inaction and non-action of the Calcutta State Transport Corporation, Your Lordship. Your Lordship, the petitioner is the widow of the deceased employee of the Calcutta State Transport Corporation, Your Lordship. During his lifetime, he opted for pension under Calcutta State Transport Corporation Death Cum Retirement Benefit Scheme. And to be candid before Your Lordship, after his option as the pension in Calcutta State Transport Corporation was very irregular, he made an application for withdrawal of the option. But Your Lordship, when he opted for pension...
Irregular in what?
In disbursing the pension under DCRV scheme. Your Lordship, when he opted for pension, the managing director of the respondent corporation intimated the petitioner that when you opted for pension under regulation 6 of this scheme, this option is treated to be a final one. You cannot re-opt.
Who is representing State Transport Corporation?
I am for the state, my lord.
Mr. Bihar, usually.
Where is he? Where is the first time?
Lordship, it is the first time.
It has never been heard.
No, Your Lordship.
Well, I'm making it not today. You inform Mr. Bihani. In spite of that, if not represented, then I have to give a direction for effecting service again. Not today, my lord.